Welcome, everyone. My name is Andrew. I'm the founder and owner of IBIS Prep, and today we have arrived at the last session of the February 2025 Florida Bar Exam Complete course. It's been a journey, but the journey is not complete. We're going to finish up with a complete review of every single subject, something to leave you all with positive affirmations and reinforcement of things that will help you get a passing score on test day. I'm very confident that if you've done the work, you should pass the test. And even if you haven't, I have some last minute materials that you could really focus on that may be able to push you over the edge. But first and foremost is album party release day. I know like 3 of you are looking forward to this. One of them is me. So let's check out what has been submitted this year. So we have Libby. I think there's a lot of political shit this year. I don't take any political stance. I'm going to run for president in 2020 as an independent, so vote for me. All right, warranties, 6 covenants. All right, the 6 covenants of a general warranty deed. The 6 covenants of a general warranty deed. The right to convey, the right of size in, and the right against encumbrances. Those are the present warranties. Then we have the future warranties. General warranties, further assurances, and the right of quiet enjoyment. I have no idea what this is saying, but that's what you need to know, right? Thank you, Libby. Awesome work for that. If it's anything political, I'm not going to take any stance on it. Just let the record show. Okay. All right, Grace. See what you got. So a holder in due course, right? This is, we'll show both of them. Don't worry, we got time for both. So a holder in due course, this is the concept in commercial paper, right? If someone takes a commercial paper instrument and then someone else takes that instrument in good faith without notice and for value, they become a holder in due course, which means they're only subject to the real defenses, not the personal defenses. Now, what if that person who holds the instrument as a holder in due course transfers it to someone else? Well, just like a bona fide purchaser, anyone downstream of a holder in due course takes shelter. So it's a really awesome album cover. All right, here we go. Void for vagueness. See, it's kind of vague. Vagueness comes up a lot on Florida essays, right? Very likely you're going to get on a Florida bar essay an ordinance or an act or some piece of legislation that's going to be problematic. Maybe it violates the single subject rule. Maybe it infringes on the people's rights to due process. But what it definitely probably likely does is it's probably void for vagueness. It's probably overbroad. Vagueness and overbreath come up a lot on Florida bar essay. So keep an eye out for them. Really awesome album cover, Grace. We're going to miss your album covers for the July bar exam, but we're going to enjoy having you come back as a guest speaker for sure. All right, let's see what else we got rocking here. I know there was some more here. I know there was some more, but some of them were in my MBE class. That might have been the only 2 in my Florida class. So I mean, you might be spared. The ones in my MBE class, I'll show you just because you'll like them. But I'll show you them tomorrow, actually. So I'm going to your assignment. There was ones that were turned in. Oh, yeah, here they are. Okay. Here we go. So we got 2 by Vicky VIP. I guess, Vicky, we didn't know this about you, but you were a cheerleader for Charlotte Hornets, Bobcats?
Yes.
There we
Hornets,
go.
Hornets.
The Hornets. Oh, back when they were the Hornets. Dope. Okay. No, they're not back when they're the Hornets. They used to be the Bobcats. Now they're the Hornets. Okay, cool. Yeah, that makes more sense.
Yeah, not way back in the day.
Yeah, I was gonna say, I was like, shit, you look really good for being that age. But anywho, okay, exclusive jurisdiction. The rap game is mine. Stay in your lane. Okay, exclusive jurisdiction. That's talking about like the Supreme Court, things they have exclusive jurisdiction over, that can't be amended or abridged, right? But the appellate jurisdiction certainly can. All right, prior inconsistent statement. Y'all switch sides too much. So this is evidence like impeaching by an inconsistent statement, the red light, green light. If you said it was red, but then earlier you said it was green, well, as long as you're available on the stand and we can cross you about it, well, we're going to bring that in as a prior inconsistent statement in Florida. Oh, this one's classic, avoidable. So this is a contract with a minor, right? If you have a contract with a minor, then it's a voidable contract. But if the minor becomes of age, then they can ratify that contract. And whatever price they ratify it at once they reach the age of majority will be the enforceable price. So obviously on a Florida essay, look out for things. If they say Tommy 17, he's a minor. If they say Tommy, a seasoned a seller of widgets, he's a merchant, right? Like understand who the parties are right here. You like this one, right, Grace? All right, and then okay, I gotta show y'all this one from Dan the Man. I don't remember what this came from, but I think it's an eggplant joke, which is like unlawful detainment featuring Terry stop, Miranda, custody, all these things. So look out for like a Fifth Amendment, Fourth, Fifth, Sixth Amendment. You gotta know the amendments to the Constitution to pass the bar exam. That's kind of like you gotta know that, right? And then we have here these ones from Andrea. She's only taking the MBE, but I gotta show them because they're just so classic. So this one right here, featuring little Ibis Pookie Bear, I think that's what you named me, is a sexy octogenarian. And this is the concept of rule against perpetuities, where if a grandmother has a clause that says the property goes to her kids who reach the age of 30, she's got one kid who's 31. Well, that's going to violate the rule against perpetuities because the 31-year-old could die, and then grandma, sexy octogenarian, has a baby, and then unfortunately, sexy octogenarian has, she passes as well. Well, then it's not sure if that clause is going to vest or not vest within 21 years because the baby has to reach the age of 30 for it to be activated. So pretty amazing. Now, this is the one, I like how she put the IBIS here. This is the one that's definitely NSFW, but because I'm putting this on YouTube and I think that sex sells, this is the last one from Andrea. Oh, Lord. This might get me canceled, but I can't be canceled. I'm uncancelable. All right, this is called Sex is Art, First Amendment fuckers featuring the uncensored. And it's the concept that art is protected, right? There's some types of speech that are not protected, like obscenity. This is not obscene. I mean, I would argue it's a little bit over the top for a submission for a law school thing, but it's still art. So obscenity, words that would incite imminent lawless activity, defamation, false or misleading commercial speech, hate speech. These are types of speech that are not protected. But art like this, and when I talk about art, I'm talking about, the background, the blue water, that's all protected. All right, so without further ado, I think that was pretty solid. Did anyone have a submission that I didn't show? SC means strictly construed against the legislator. All right, strictly construed. All right, cool. Now that leads me into a nice segue where I get to teach the entire Florida bar exam in due time. So let's start with contracts. Contracts, the key to contracts is that the mnemonic for the Florida bar, buy friends drinks, big drinks. Body of law, formation, defenses, breach, and damages. And if you're wondering where can you learn about contract law and you got to learn at the last second and oh man, the exam's coming up tomorrow, you need a copy of my book. This is me and my grandfather, the one and only, that's my guy right there. Rest in peace, right? And then this right here is where I have everything about contracts. And you see, I tell him the mnemonic, I'm talking to this imaginary character. I tell him the mnemonic, buy friends drinks, big drinks, because it's a really easy way for us to navigate a contracts essay for body of law, contract formation, defenses, breach, and damages, right? So, body of law, we have UCC for goods, common law for land or services. You want to talk about who are the parties? Are they merchants? Is it a minor? Or are there like special rules that apply to merchants, right? Then you want to identify what type of contract is it? Unilateral, bilateral, installment, requirements, output, options, firm offer rule, divisible contract, quasi-contract. Like the more things you could talk about, the more points you'll get. So here, it is important to note that the parties are merchants because there are special rules that apply to merchants. Here is important to note because it is an installment contract, which means that one non-conforming shipment will not constitute a material breach and there will be an opportunity to cure, right? There's like extra points you can get by stating more things, right? Okay. And then contract formation, right? Offer, acceptance, consideration, give them nice little definitions. Don't spend too much time on this part. If you look at the model answers, they kind of like, hit it and quit it, right? Like they just, I can't believe I fucking said that. They just do offer from, can we edit that out of the YouTube? They just kind of go quick with the contract formation, offer, acceptance, and consideration. They just say it, give a definition, and move forward and see if it occurred, right? Like if there's dates, do it chronologically, identify what happened and such, but don't spend 20 minutes doing contract formation. Some of the model essays really just do it quickly. That's a better one. do it quickly. So these are some interesting contracts, interesting concepts about contract formation. Mirror image rule, battle of the forms, knockout rule, UCC central terms test, mailbox rule, invitation to deal, advertisements. Make sure you know what all those things mean. Definitely focus on these concepts: battle of the forms provision, mirror image rule. Mirror image rule at common law, that acceptance must match the offer exactly. And then battle of the forms provision is, an additional term under the UCC, so long as it's not material, will be included in the contract if it's part of the acceptance. If it's material or it's conflicting, it'll be knocked out and UCC gap fillers will apply. So make sure you can really, walk the reader through that conversation. Defenses always start with the statute of frauds, contracts in contemplation of marriage, contracts that cannot be completed with 1 year, contract for land, executorship, goods over $500, and suretyships. My legs, right? But what I teach students is don't just tell them about my legs, right? Also tell them about swap. Someone was supposed to make the swap album, and it was supposed to be that wet ass, I mean, you know the song by Cardi B, that swap, that, right? I'm trying to make it so you remember these things, right? That's the concept. So swap, consider swap with, it's Cardi B, right? Am I right? Yeah. She's got the WAP, right? So swap, specially manufactured goods, written confirmatory memo, admissions in court, promissory stop on partial performance. I'm very mechanical. Tommy, the issue is whether the contract needed to conform with its statute of frauds. Under the statute of frauds, there are certain contracts that must be in writing and signed by the party to be charged. These contracts include my legs. Exceptions to the statute of frauds include swap. Here, Tommy will argue that it should have been writing because those goods were $500. Johnny will counter that because the goods, had the S money pendant, they were specially manufactured, and therefore it did not need to be in writing. Alternatively, Johnny will point to the email he sent, which may constitute a confirmatory memo because it was between merchants and it contained the essential terms under the UCC, which are identification of the goods and quantity. It is important to note, that's my favorite term, it is important to note that price is not an essential term in the UCC. Is it important to know that? I don't know, but I'm going to try and get a point, Important to note is the way of telling the reader, like, let me try and get a point here. It is important to note that this thing I couldn't fit in may be on the rubric, and I'm going to say it here. That's what important to note means to me. Okay, so if you do statute of frauds, you do swap mnemonic, you're killing it. Then you could talk about all the other defenses: mistake, mutual or unilateral, defenses to formation and execution. These start with a lot of I's. If you can't remember defenses other than the easy ones, statute of frauds, mistake, fraud, duress, misrepresentation, those 5 are obvious, right? Get it, got it, good. But the other ones are kind of like, I can't remember them. There's a lot of them that start with I's: incapacity, illegality, intoxication, infancy, illusory. These are all incompetence, right? All start with I's. Undue influence, I guess the word influence, right? And then a couple that start with U, right? Unconscionability, undue influence. And also the ones that start with I: impracticality and impossibility. So those are defenses to execution. These are defenses to formation. It all makes sense. Unclean hands, latches, acquiescence. Unclean hands, like you were in bad faith too. Latches, you waited too long to bring suit for the breach of contract claim. And acquiescence, like you allowed them to do the thing that you are now saying that they weren't allowed to do, right? So contracts essays, in my personal opinion, are the easiest essays to navigate. You just go through the mnemonic: buy friends drinks, big drinks, body of law, formation, breach, defenses, body of law, formation, defenses, breach, damages. So you gotta make sure you got it straight. Body of law, formation, defenses, breach, damages. If you can go through those 5 prongs and really flesh them out, you've done 80% of the work. Maybe you have to identify some other things after that, but that's going to be 80% of the work. And Florida essays really like you to be flowery and write a lot, right? UBE, it's, right to the point. Florida's it's important to note that they could have argued for all these things, although none of them would have prevailed, right? Okay, right, you don't have to argue for all of them, but it's certainly prudent to argue for the relevant ones. Again, you have to balance your time. 1 hour per essay, unless you have a time extension, maybe 1.5 or 2 hours, whatever it may be, but balance your time and march through it accordingly, right? So don't go too long on one essay at the sake of another essay. I'd prefer you spend 1 hour on each essay, and then at the end, if you have some time, then go back and spice an essay up. But you really want to march through the essays mechanically, but don't get lost too much in the weeds, because you need to move through it and address all the issues within time. Speed is definitely an important part of Florida essays. So that's why I'm trying to kind of keep that energy, my energy. I'm always fast. I'm always, up, right? Like I'm always positive, moving forward. That's the type of energy you need on test day. All right, the breach could be material immaterial for sure. Anticipatory repudiation, right? An unequivocal intent not to honor the obligations of the contract. Talk about the perfect tender rule, right? One way I like to think about this is UCC versus common law. Common law is more strict when it comes to contract formation because it's the mirror image test, right? Offer and acceptance must match exactly. Whereas UCC is more lenient, it's more liberal. It's like, okay, well, there could be an additional term. If it's not material, then we still have a contract. So common law, more strict when it comes to formation, UCC more lenient when it comes to formation. Now, when it comes to execution, it's the other way around. Common law is like, oh, substantial performance. Like, yeah, Andrew, he was on Miami time. He was a few minutes late. Like, he still performed. Whereas, like, UCC is perfect tender. Andrew said he was going to ship me 50 red widgets. He sent me 49 red widgets. That's not, perfect tender. So understand that more strict for common law in formation, more strict for UCC in execution. Cool. I don't know. Every time I do this, I'm expecting like fireworks or like balloons to go off, but I don't know how to actually do it. But I like that it's rare and random. All right, so damages, I like to write damages first. You give me a good contracts essay and I'll comb through it. And if it says A, B, C, and D, and C says what damages are available, and D says what ethical issues arise, I'm writing those two first. Because I know when I get to ethics, you'll be like, yeah, Andrew's got ethics down. I mean, watch Rebecca's video. She's got down way more than me, but I'm just saying I got like my nice little speech down. But, ethics is an area you can just crush right away, gain confidence. You don't even have to read the essay. Just start writing about the, where the rules of ethics come from. Same with contracts. I don't need to read a contracts essay to introduce the reader to the idea of damages. I'm going to hit him with the same conversation every time. I'll literally read it off the paper. Let's see what I wrote. I trust my former self that I wrote something hot here. Let's see. Damages for breach of contract can be either legal or equitable. Legal relief is monetary and can either be compensatory or punitive, although punitive damages are very rare in contract law. The most common type of compensatory relief is expectation damages, which put the non-breaching party in the position they would have been without the breach. Consequential damages are damages that are foreseeable in light of a breach, and incidental damages are damages that arise as a result of mitigating circumstances. Lost wages, lost profits, reliance damages, and restitution are also forms of legal relief. One way to measure damage is the cost of cover, which is the cost of replacing the missing or non-conforming goods at market price. A non-breaching party will always have a duty to mitigate damages wherever possible. Really fire. I mean, I could add, I'm sure I added somewhere else, liquidated damages, which I do add. And honestly, if I was going to be super ticky-tacky about it, I would say nominal relief as well, in name only, but like whatever, it's not really legal. Okay, so what about equitable relief? Equitable relief is court ordered and includes specific, look at me critiquing my former self, like 98%. Equitable relief is court ordered and includes specific performance, injunctive relief, reformation, rescission, replevin, nice, promissory estoppel, and enforcement of quasi-contract. Specific performance is typical for land or unique goods, such as art, but is almost never appropriate for services, as this would equate to indentured servitude. Legal relief is the preferred remedy, and equitable relief is only appropriate when monetary damages would not suffice. Like this right here, this shit right here is amazing. I write this down right off the top. Give me the essay, boom, I'm writing that down. And then I'll write here, comma, and then get back to it later. But I've already gotten hella points because I introduced the reader to the concept of damages. When I teach people how to write essays, it dawns on me that's not that hard, right? You know what you're going to write about. They give you a con law essay, you're going to write about due process, First Amendment, equal protection, strict scrutiny. Like, you know what you're going to talk about. So you can already like get to the writing. The analysis part, that's, the hard part. I mean, yeah, like it's hard. You don't have much time, but just take a crack at it. But as long as you have, sharp rule statements that are on point, you've done half the work already, right? All right, so some other issues that we could talk about. I mean, I said this too. I often tell essay writers to try writing the main points of damages before any other heading, even though it will appear at the bottom of the essay. I remind students that the reader does not know how you constructed the essay, and since examinees often run out of time, it may be prudent to at least discuss the general differences between legal and equitable remedies quickly to start the essay, although physically placed below the rest of the essay. Do you see what I'm saying here? Like, you can write 1, 2, 3, 4, write parts 3 and 4 first because they're easy, and then write parts 1 and 2, and the reader's going to read it from top to bottom. Right. So they're gonna be like, oh, this dude he came on strong at the end. Like, no, I didn't, bro. I started strong. I just put it at the end. But like, you know what I mean? They don't know how you read it. So it's strategic. right? There's different considerations for different students, different strokes for different folks, but it's not a strategy for everyone, but that's kind of how I roll, right? All right, other issues, parole evidence, look for exceptions to parole evidence you could talk about, condition to contract, to clarify ambiguous terms, to show a defect information, to show an additional term, to show customer trade usage, right? Non-compete agreements, they're kind of on their way out from what I hear, but in Florida, they can still be tested. The things are they must be reasonable in geographic scope, in subject matter, and in duration. Liquidated damages clause, they're to contemplate damages ahead of time because they'd be too speculative in light of a breach. Liquidated damages are common in like construction contracts. That's what my uncle does. Construction law is like, oh, there's a lot of delays, right? They're supposed to do this by this date, but if they don't do it by this date, it would be too hard to measure in the midst of the project. So we're going to calculate in advance. Remember, liquidated damages must be reasonable and it cannot operate as a penalty. Typically in Florida, they're limited to 20, 30% of the contract price. I think 20% is the typical number. Accord and satisfaction, an agreement to pay a lesser amount than owed, and satisfaction of the payment amount. Satisfaction will extinguish the original debt. I did my best, like you can tell. I did not use no chat GPT when I wrote this essay guidebook, right? Like I wrote all this shit. I tried not to use notes because I tried to put myself in the position of someone writing the essay and being like, how would I write this, in my own language, quickest and to the point. So like, there's a lot more I could tell you about an accord and satisfaction, but if I'm writing an essay, that's fair enough, right? Assignment, delegation, novation. Assignment, transfer the rights of a contract. Delegation, transfers the duties. And novation, substitution of parties. Third-party beneficiaries, right? That's, intended or incidental. Those are some good stuff to consider on a contracts essay. So with that, yeah, I mean, I think contracts, you should be ready for a contracts essay. That's one of the ones that's the fastball down the middle, Vicky, I know Vicky VIP was just doing an event with Big Poppy. I was literally going to say Big Poppy without even thinking about that. But like, yeah, just hit that one out of the ballpark. It's easy subject. Go crazy on the contracts essay. That brings us to torts. Torts is honestly my favorite subject. Love torts. I don't want to practice personal injury law, but I understand it. I know what the arguments are. So let's talk about it. Always on every Florida essay, you can mention these three things. Florida is a modified comparative fault state. That means that Florida recognizes contributory negligence as a viable defense. However, a plaintiff that has greater than 50% falls barred from recovery, right? Florida's abolished joint and several liability. This means that plaintiff must seek damages individually from each defendant to the respective proportional liability. That's for negligence claims. There are some times in Florida you can get joint and several liability, like for instance, a partnership, right? If we're doing partnerships. Yeah, partnerships, yeah. And then in Florida, punitive damages for negligence are limited to 3 times compensatory damage or 500,000, whichever is greater. There's some exceptions, such as abuse to the elderly, where the cap does not apply, right? So I cannot overstate the importance of mentioning these 3 things in every torts essay. Look at that jewel I've just dropped on you all. For everyone who's watching this, on YouTube the day before the exam, that's a crazy jewel right there. That you get a torts essay. You can automatically write those 3 things and potentially get rubric points. Hey, maybe you won't for one of them, but you won't get a negative point. So why don't you drop them off the rip, right? Like modified comparative fault, abolish joint and several liability, punitive damages are limited 3 times compensatory or 500,000, whichever is greater for negligence claims. Boom. Okay. So here we go. I told you to mention those things. Modified comparative fault, abolish joint and several liability, 3 times compensatory, $500,000 or greater than 2. We talk about duty, talk about breach, causation, damages. You really got to understand those things. I feel like if you're taking the bar in 3 days and you don't understand duty, breach, causation, damages, you might be cooked at this point. But make sure actual is like, but for cause, and proximate is foreseeable plaintiff or the zone of danger. Andrews or Cardozo, one of those theories. Negligence per se, a statute that determines liability. When I took the California bar, by the way, I know this is a crazy thing that I don't think my biggest detractors are here right now. Oh, Alex is here, but Nat and Vicky are not. Okay, so Alex will think this is crazy. But if any of y'all know Kim Kardashian, she has posted that she's postponed the California bar until 2026 because she's just started the material. I'm telling you, give me 2 weeks, Kim Kardashian. Give me 2 weeks, Kim Kardashian, and I can have you pass this California bar exam. Ideally, give me 2 or 3 months. I want a cabin. I want a butler. I want a maid. I want a chef. I want cold plunge, hot tub. I want all the amenities. And some money, but the money's not even that important. Kim, I'll do it. I'll do it for the amenities and to get it done. But I could definitely have anyone passing these bar exam. It's not that hard. We just got to be diligent and we just got to learn the law, right? So negligence per se, crazy transition, is when there's a statute that creates a duty of care. Like when I was writing the California bar, there was a question that said, you know, Tommy is at a mental patient. He's got mental problems, and he sneaks into the kitchen. And this is also Alex will be. She would be really fucked if this happened to her. But Tommy sneaks into the kitchen and puts peanuts into the hospital food, right? And then someone has a peanut allergy, and like, I think they die or something really bad happened to them. So there's all these arguments to be made, and I made a little cheeky argument that said if there was a statute or ordinance in the jurisdiction, then there could be an argument for negligence per se, that the hospital had a statutory duty to maintain, food standards to a certain level. They breached this duty, XYZ. And there's like, however, this argument probably failed because Tommy literally broke in, supervening, peanut bandit, XYZ. But in my mind, I had this moment of brilliance. My students make fun of me for saying that, but I had a moment of brilliance where I was like, this is smart. No other students are talking about this. So that's kind of how you want to feel on test day. If you can be like mentioning things that other students aren't, it's a good feeling. As I like to say, and I'm pretty good at this. I have my moments of lapse, but take detours, not frolics, right? It's okay to take a cup of coffee as you're writing the test, but a frolic means you just totally went off into the, out of the scope of the issue. So take a little detour, not a frolic. The Kim Kardashian thing may have been a frolic right there, but since I'm putting this on YouTube and someone could potentially send it to Kim K, and I really do believe in my heart I could easily help her pass the California bar exam, it was a necessary frolic. All right, back to it. Vicarious liability, literally what I was just talking about, detour versus frolic, they can be held liable under that theory of respondeat superior, third-party liability. So like, look for the employer-employee. It's tested a lot. Vicarious liability. If you see employer-employee, you need to talk about this. Respondeat superior, third-party liability, detour, frolic, within the scope of business. Like, don't let that one go over your head. You know what I mean? If you see employer-employee, it's triggering vicarious liability. If you see 14-year-old Johnny, it's because he's a minor. If you see Susie, who sells seashells, but she's been selling seashells by the seashore since 1776, then she is a merchant of seashells, right? All right, strict liability. So Florida has abolished the one bite rule. I have a hit staffy. I wasn't allowed to admit that until like 2 years ago when they changed the rules in Florida, but yeah, that's right. She's been a pit the whole time, and I'm not getting, they're not going to take it away from me now, but she's a pit staffy, right? So I have to be very careful, you know what I mean? Like, if she were to bite someone, like that would be a terrible thing because Florida's abolished the one bite rule. Even if she hasn't, known to be aggressive or not, I could be held strictly liability for a dog bite. So that's some concepts of strict liability, right? Strict liability for wild animals, strict liability for inherently dangerous activities, and strict liability for products liability, which I'm sure I'll talk about in just a minute. So breach, causation, I talked about the actual and proximate. When I'm grading essays, I see this missed on most essays for torts, right? Superseding versus intervening events. I don't know why, but I see it missed a lot. So let's try to not miss it on test day, right? Think about it. If all other students are going to miss it, let's try not to miss it. So yeah, like if Aunt Martha, put the cookies in the cookie jar, well, then maybe that was a superseding or intervening event, which would, lead to contribution or indemnity on behalf of the employer, right? Like that was superseding. Something happened in between that could cut off the chain of liability. We call that superseding if it totally cuts it off, and intervening if it only, contributes to it, and that would be a contribution. Damages, compensatory damages, including pain and suffering. So this is a good thing. People suck at damages on contracts, but even more so on torts. You got to mention these things. Compensatory damages for torts include pain and suffering, emotional distress, mental anguish, medical expenses, loss of wages, diminished earning capacity, loss of consortium, ability to share one's company, and out-of-pocket expenses. It is important to note that for prox liability cases, Florida follows the economic loss doctrine, which states that a plaintiff cannot recover for purely economic losses. Sorry. If someone doesn't mind muting their mic, I got a little feedback. But just give me a second. Sorry about that. So the economic doctrine, which states that a plaintiff cannot recover for purely economic losses, since this would more properly constitute a breach of contract claim. When discussing damages for negligence, remember to discuss the 3 times 500 cap on punitive, which are designed to punish defendants for willful or wanton behavior. When discussing damages, you should try to mention the available damages while also discussing which damages would not be available. For instance, a claim for lost wages for a job a person who was applying for but is not secured but is not secured a job would probably be too remote to constitute measurable damages. For all types of civil damages, Florida recognizes the eggshell plaintiff theory, which means that defendant is liable for all of the plaintiff's damages, no matter how susceptible the plaintiff is to injury. So yeah, like eggshell plaintiff rule, economic loss doctrine, these are just some, cherries on top you can get when you're talking about damages. Negligence, always look for negligence on every torts essay. Even if it's products liability, strict liability, there's an alternative theory of negligence. Remember, who are personal injury attorneys in society? And whether you like it or not, it's going to be a lot of y'all, because I have so many students of mine, I'm in position to say this now, who tell me when they're studying, I would never be a personal injury attorney. And then like a few years later, they tried it out all out. They're like, well, they make the most money, they don't work that hard or whatever. I'm like, okay, I'll see you, Morgan and Morgan, right? Like it'll happen to you too, right? Personal injury is a huge practice of law. It's one of the types of law where you get rewarded for how hard you work, because if you can get more money out of the insurance company or whatever, you'll get more money for your client and for yourself. So there's certainly pluses and minuses to every type of law. I at the moment prefer teaching, but one day I'll start a law firm. One day I'll run a hedge fund. One day I'll be president. I don't fucking know, right? Whatever. But right now I'm teaching, and I like what I'm doing with teaching. And the thing is with personal injury attorneys, when they're filing a complaint, they're filing every claim under the sun. They'll be like, Tommy was negligent, that's why my plaintiff got injured. Alternatively, Tommy, is liable under a strict liability theory. Alternatively, Tommy is liable because, a breach of contract. You know what I mean? Like you're just trying to throw as many claims as possible. So negligence should pretty much come on every single essay. Like who did something stupid, like negligent hiring, negligent firing, negligent supervision, negligent design, just deviation from the standard of care. All right, so NIED appears a lot, negligent infliction of emotional distress. This is pretty tough in Florida, so I'm going to read it aloud because this actually required a lot of research on my part, even from the Florida bar materials themselves. So NIED appears the most. NIED requires that the plaintiff must suffer a physical injury. The plaintiff's physical injury must be caused by the psychological trauma. The plaintiff must be involved in some way in the event causing the negligent injury to another, and the plaintiff must have a close personal relationship to the directly injured person. There are some exceptions to requiring physical injury, which is known as the impact rule, including negligent mishandling of a corpse, an accurate disclosure of an HIV test, claims involving wrongful birth injuries such as stillborns, defamation, and invasion of privacy claims. Florida courts have consistently relaxed the need for physical impact and recently modified the rule in bystander cases by excusing the lack of physical impact. In such cases, recovery for emotional distress would be permitted when one suffers death or significant discernible physical injury when caused by psychological trauma resulting from a negligent injury imposed on a close family member within the sensory perception of the physically injured person. So they've actually been constantly relaxing this physical injury requirement that's originally stated and in bystander cases and in all of these cases. So like you can just have that discussion. Just because they're not suffering a physical injury on an essay does not mean you shouldn't argue for NIED for sure. So Florida dram shop laws, they've never tested this, but I did see an essay where they said do not discuss Florida dram shop laws. And you know what I mean? If they're going to tell me what to not to discuss, I'd like to at least know what they're telling me not to discuss, or give me more confidence. So I'm going to teach y'all what Florida dram shop laws are. Florida dram shop laws means a person who sells or furnishes alcoholic beverages to a person of lawful drinking age shall not thereby become liable for injury or damage caused by or resulting from the intoxication of such person. So it pretty much, it protects the bartenders. And in Miami, we need that, because think about it. You're at Club Live on a Tuesday or whatever, and it's packed, and the bartender's, selling drinks, and then someone goes out and hits someone like, oh, you should have known. It's like, dude, I had 1,000 idiots buying drinks. How was I supposed to know which was the drunkest idiot of them all, So, there's a reason for Florida dram shop laws. Now, again, there's always arguments that like, if the dude came into the bar and he was shithouse hammered and you said you really look drunk, I don't think you should drink more. And they're like, you know what? Life is short, and you serve them a drink. Like, I mean, that is a different story, but this is just a general statutory law. All right, so intentional torts, make sure you got to know the intentional torts. Throw the kitchen sink at them, assault and battery. If anyone is touched on the bar exam, I don't care if they're touched by, I know I'm going to make this, and it's a weird, crude example. I don't care if they're touched by a fart. It's assault and battery on the Florida bar exam. I don't care if, someone blows on them, if it's a wet willy, like assault and battery. If anyone is touched, you're going to argue for it. The example I remember is the Aunt Martha one. Aunt Martha spikes the cookies. Tommy eats the cookies. Tommy's, doing the Harlem Shake on the dance floor, and he falls back and falls onto little Susie. Well, is there an argument for assault and battery there? I mean, there's an argument. It was an offensive touching. Little Susie got touched, right? Now, did Aunt Martha touch little Susie? It's a fucking weird example, but like, no, not really. So the argument for battery is going to probably fail, but still, you're going to make the argument and moot it because there was a touching. So if there's a touching on the bar exam, I want y'all to talk about assault and battery. False imprisonment is pretty obvious. Trespass to land, trespass to shadows, conversion, know the differences between them. Trespass to land is walking on someone's property or throwing a rock on someone's property or something of that nature. Trespass to shadows is, borrowing the car. I actually did this morning. I know you guys are going to sue me, but me and my next door neighbors, I always have different next door neighbors. It used to be this dude, Adrian, who was an attorney. He went to St. Thomas. He's the man if you need a real property attorney. But him and his wife moved out. They had a baby. Now it's this new couple with the baby. And they had they're so active. They got 3 dogs, 1 baby, and they got all these activities. They play paddleball, they're riding bicycles, and the one dog's in a wheelchair. I can't make this up. So anyway, they had their bikes out today, and they're like getting the baby, putting a little helmet on the baby. And I was bored. I was just got off the phone with some lady talking about the bar exam. And then I took the bike for a little joyride. I just needed that moment. So I just took the bike. They're my friends. It was funny. But then I gave it back to them. We were laughing about it. But yeah, that's trespass or shadows. I took the bike, took it for a little joyride, and I deprived them of their use for it. I thought to myself, damn, I need a bicycle. Pretty good for the mental state. All right, conversion is what if I took the bike and I just never gave it back to them, right? Conversion is like the civil equivalent of larceny. IID and NID. If you talk about NID, talk about IID. Because they're like a peanut butter and jelly, right? You'll argue for NID, and then you'll say, Tommy will argue that it was intentional. And remember, the key terminology for IIED is going to be outrageous, right? It was outrageous conduct that caused actual emotional distress. And then some of the lesser tested intentional torts are malicious prosecution, intentional endangerment, reckless driving, right? And then defenses to intentional torts. So if you talk about the argument, you want to bring up the counter argument. I think I'm really keen on teaching that you can expand your word count by giving the opposing argument. I teach my students this: if you're a lawyer, you're going to represent who pays you, right? You don't always represent the good guy. You don't always represent the stronger argument. So when you write your argument on the test, Tommy should prevail for breach of contract, or Tommy should prevail in a negligence claim, duty breach, causation, damages. I want you to take that cap and flip it around, right? And now you're on the defense, or now you're the plaintiff, right? Now you're arguing for the other side, and you're getting paid. And you're like, all right, well, what's the best argument they're going to make? And make that argument. And then on balance, the court will likely side with the first argument, right? But at least give the reader the opposing argument. And there's 2 reasons to do that. Number 1 is because it expands your word count. It helps you get more rubric points and all that. And number 2 is, I'll venture to say that not a single person on Tuesday's exam is going to get every issue correct. So you might take the wrong side from the beginning and then turn your hat around and argue the weaker side, but you were actually wrong, and that's actually the stronger side. So in that case, you saved yourself by at least mentioning the actual correct answer. So essays, if you write them how I would hope that you would write them, gives you the opportunity to get more points even if you don't know the answer. Where multiple choice, like Florida multiple choice and MBE, you're right or you're wrong, right? I say close only counts in horseshoes, hand grenades, and Florida essays, right? You can be close and still get points, but you can't really do that in multiple choice. And then finally, there's other torts, so negligence, intentional torts, and then some other things that should be memorized. Defamation, they test a lot. Defamation, slander, if it's spoken, libel, if it's written or publicized. Defamation of a public person requires actual malice, where if it's a private plaintiff, it's just mere negligence. And then Florida has that media defendant rule where the newspaper will have 10 days to retract a defamatory statement if they provide notice within 5 days of the publication. Also heavily tested is the mnemonic for slander per se, crimes of moral turpitude, loathsome disease, unchastity, and about a person's business. The mnemonic is club. That's where you'll find me in between, this exam and the next exam. I'll be there, but right now we're staying focused and working. Defamation. So look for that. Did someone say something injurious about another person's reputation that could amount to defamation? They like to test it a lot on the Florida bar because there's a constitutional consideration. Well, maybe there's a freedom of speech argument, or maybe there's a right to privacy argument. So they like to kind of weave the torts and con law essays together, and defamation is a great place for them to do that. They did that on my year, February 2017. It was defamation, and then there was a sunshine law implication, right? It's con law, torts kind of crossover. Invasion of privacy. So the mnemonic that I teach people is IFLAP, intrusion upon seclusion, false light, appropriation, misappropriation, and then public disclosure of private facts. But recognize that Florida does not recognize a separate tort for false light. They wrap that up with defamation. So it's just going to be intrusion upon seclusion, appropriation, misappropriation, and public disclosure of private facts. These two are tested a lot, right? Premise liability and prox liability. And by the way, Meryl, I see you. I'm almost done torts, and then I'm going to give you the most amazing moment to shine. We're going to love it, but I see you. Premise liability is when someone is injured on someone else's property, right? It's simply a negligence argument. There's a duty, breach, causation, and damages, but you got to at least use the proper terminology. Premise liability. Don't be like, oh, this is a land dispute, hurt, injury. You know what I mean? Like, don't talk like a child on this test. Say, the issue is whether Tommy will prevail in a premise liability suit. In order to prevail under premise liability, they must prove the elements of negligence, duty, breach, causation, and damages. In order to establish a duty, it's necessary to determine, what the status of the injured party was. Were they a licensee, an invitee? Were they a known trespasser or an unknown trespasser? And, in a Florida torts essay, look out for a situation where licensee or invitee exceeds the scope of their privilege, opening a door marked employees only, and how their status arguably has changed from invitee to trespasser, right? You're a business invitee. You're at the IBIS Prep store. You're buying a bunch of, IBIS Prep goodies, and then you see employees only, do not enter. And you're like, ooh, I bet you Andrew's doing some cool stuff back there. And then you open the door, you go back there, and you get attacked by Rosie, right? Like, especially if it had a bad dog sign on it. Not that Rosie's a perfect dog, but I'm just saying, like, if that were the case, then, maybe you assume that risk, and maybe your status has changed from invitee to trespasser, and you really want to flesh that out on the essay. So again, premise liability, heavily tested, defamation, heavily tested, and products liability. I don't know why. I have a feeling it could be tested this time. I don't know why. It's just something that I have like an inkling towards. I had a really weird dream last night. It had nothing to do with the bar, but like, if I have a dream about the bar, I'll let y'all know. So products liability, again, there's always a contemporaneous argument for negligence. They were negligent to design it, produce it, or manufacture it that way, let's say. But the strict liability argument is where you'll get most of your points. Remember, strict liability applies to wild animals, inherently dangerous activities, and then also products liability. Products liability means a designer, manufacturer, supplier, producer, retailer placed a defective product in the stream of commerce, and anyone downstream of the defect can be held liable. There's different theories of strict liability for products liability. There's the design defect, which means that it fails the risk utility balancing test. The risk of designing it one way outweighed the utility of designing it that way, let's say. There's the manufacturing defect, which means it was designed properly, but it was produced wrongly. It came off the line differently. There's the express warranties, like inadequate warning or failure to warn. And then the implied warranties of merchantability, whether or not the thing works, and fitness for a particular purpose, that the thing works for the reason it was specifically warranted for. So if you're marching through a products liability essay, negligence, you're gonna get all your points for, duty, breach, causation, damages. Then you go through all the different theories: design defect, manufacturing defect, express warranties, failure to warn, inadequate warning, implied warranties, merchantability, and fitness for a particular purpose. 1,000 words later, you're talking about, maybe not that many words, but my point being is, like, if you know how to organize and categorize yourself when you're writing these essays and identifying these issues, there's a lot to talk about, and you could, just march your way through it mechanically.
Hey,
So,
Andrew,
yes, sir. What's up?
quick question. Can you expand upon the fitness for a particular purpose and the merchantability difference? Because I mean, the particular purpose I kind of get because it's in the name, but I don't get the difference in that and merchantability.
Fitness for particular purpose, again, it's in the name. So, like, if I sell you a canoe and I'm like, yo, this canoe is fit for the river. I don't know. My brother does a lot of kayaking, like the Nile. I know that's a weird ass river, but let's just say this canoe is fit for the Nile River, right? And then you take that canoe in the Nile River and it gets blasted up, right? It was not fit for that particular purpose of being on the Nile River. Now, merchantability just means like, does this canoe work? Will this canoe float on water? Does this canoe, if you sit on it, will it paddle? Like, is it a workable canoe? The best way to think about merchantability, I always think of a television. Does it turn on? Right? Is it merchantable? If I sell this TV to someone else, would it turn on? Now, does this TV get the boxing match, on Saturday night? If you warranted it, that it specifically would, that would mean it's fit for that particular purpose. Merchantable just means it literally works. So here, if I think when I talk about merchantability, how do I define it? Merchantability requires a product to function generally, right? Literally to function generally. And fitness for a particular purpose refers to a warranty for specific use. That's a really, wrapped up tightly sentence that you can use. Merchantability requires a product to function generally, and fitness for a particular purpose refers to a warranty for specific use. By the way, Meryl, I know you're writing a book. This is my book right here that we're going over, and this is my cover photo. My grandfather and me just had to shout that one out. Okay, so then lastly, things that we're talking about on torts is wrongful life, wrongful birth. So Florida does not recognize wrongful life. Wrongful birth has to be brought by the parents, right, for failure to disclose the health problems of an unborn baby. Wrongful death, so the civil version of manslaughter. Survivorship claims, we can distinguish survivorship claims and wrongful death claims. Wrongful death, think of like the doctor, like the malpractice, like that's the reason why they died. Survivorship claims, think of like, oh, these people are the estate, and Tommy passed away, but before he passed away, he had money to collect from Johnny, Susie, and Bradley. We can, on behalf of Tommy, collect. Those are survivorship claims. Medical malpractice, not heavily tested, but just know that they need to provide notice. There needs to be a third party who verifies that it is actually let's say a valid claim. And then there's the option that the medical practitioner has of arbitration or mediation, and there's caps on non-economic damages. I tried to keep this really brief because I could have written a 100-page book about medical malpractice. And then a nuisance, right? That's just someone being annoying. Like, my neighbors are cool, but they got a baby screaming all the time. They got a dog in a wheelchair who barks like wow, 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 wow. That's how he sounds. Like I could claim nuisances. And then me, I got Rosie, she barks pretty loud. Like, sometimes I like to have parties. Not really, but maybe I did. Like that would be like different examples of nuisances if it would be annoying to the common person, right? Examples include noxious odors, loud music, or continuance of a barking dog. All right, so that's pretty much torts. I'm gonna, take a quick commercial break, and we're gonna come back. I'll do con law, real property, ethics, family law, and the multiple choice subjects. I'm gonna spend less time per subject, just highlighting the highlights, but I wanted to take a little break. Meryl, are you with us? Amazing. Let me see if there's anything in the chat that's literally of value. Will you take the new California bar since I've gotten rid of the NCB? I can't technically, but my boy CJ's taking it. I sent him, he's my lab rat, CJ, so he'll tell me everything that's on it. I've already passed the California bar. You're not allowed to take the same bar twice, unfortunately. Sean's Island finished for a particular purpose. All right, Alex, good work, Alex. I appreciate the help. And that's that. So without further ado, we're going to take a commercial break. I warned Meryl that if she came in the middle of class, I was going to put this on YouTube. And she said, I am YouTube. I'm ready for that. So she's here. Meryl is a celebrated mind power coach. She is a professor at the University of Miami. And she does a program that's coming up in April. I'll be part of that program as a student, so I hope you join her. Meryl, please, when you're finished, put your information in the chat so that they can join. I'd ask you kept it short to 5 minutes maximum so that we can get back with the lecture. But, advice that you have for students who are literally taking the bar exam on Tuesday. I know in only 5 minutes, it's not the easiest instructions, but the best you can do to just kind of give them some positive affirmations and things that you would professionally advise them for when they're taking the bar. And I wouldn't be doing this in the last minute if it wasn't extremely valuable. Meryl is the best of the best. She's hired by, people making the type of money I dream of to help them be even more successful. So she's, really well qualified, and there's no person I'd rather have here right now than her. So Meryl, do you have any advice for the students who are about to take this exam?
Thanks, Andrew, and I appreciate the kind intro. Yeah, so I'm gonna hit that in just a second. What I'd like for you guys to do, if you don't mind, take just 30 seconds, and if you could put into the chat, what is the concerns right now as you get ready to take this test? What's the fears? Put it into the chat, or if you want to unmute yourself, go ahead. Time management, not passing, failing, running out of time. Anybody else? Anxiety from time. Time is a big one, huh? Reading comp from rushing. Okay, so yeah, being able to finish. Florida MC. What else? Blocking in the test. Okay, so blocking meaning like you just kind of forget. Rushing because of confusion. Yes. How many of you are sitting in this place right now? You are days away from going in and all of this work, energy, and effort. And in a moment, what are you going to do to make sure that you deliver and that you actually do everything that you need to do? At this point, you have to trust in the fact that you have done the work. I know everybody in this class has been prepping for this for months, multiple times a week, day after day, night after night. You have given your heart, soul, blood, sweat, and tears to the energy that you have put into making sure you are prepared for this test. The one thing at this point that will take down your goal is what is going on up here. If you cannot get on board with the certainty that you have done the work, that you have done everything that you possibly can to make sure that your readiness is there, and that inability for you to be 100% certain can literally take down the whole house of cards. So from this point forward, what you need to do is to move yourself from a place of somebody who is preparing to take a test, and you need to start to think of yourselves as athletes who have been on a marathon training route, and now you're in the home stretch. So I want you to move yourself from being somebody who is studying for the bar to an athlete getting ready for their moment to shine. Whether you consider it game day or race day, this is that time. You're days away, so what do you need to do? You need to start moving to protecting your mind and your body in the ways that are going to help you. So proper sleep, proper hydration, nutrition, making sure that from now until after you've taken that test, that all of those things are working in your favor, making sure you're getting enough water, that you are sleeping a good night's sleep, that you are eating well and fueling your body with only food that is going to help you be in the best place possible from nutrient standpoint. And then what I want you to do is I want you to take all of that, and on top of it, I want you to start feeding your mind with belief, with the fact that you have done everything you need to do, that you are certain in your answers, that you're going to take this test with ease and confidence, that you need to be able to trust that you're going to recall what you need when you need it. You're focused, you're sharp, and you're prepared, that you're embracing the pressure because you know that it will fuel your success. Own the moment and know that you will succeed. Say to yourself, I believe, not doubt. I defy the odds. I am certain in my answers. I have done the work necessary to be where I am right now. I'll take this test with ease and confidence. I'm going to trust in my mind to recall what I need, and I am going to fly through with the time that I have, and I am going to be at my best. I'm going to rise to the challenge. Time is not the issue. It is all about the confidence and the energy, effort, and strength you put behind the certainty of your answers. Be focused, sharp. You are prepared. Embrace the pressure and know that it will fuel your success. The certainty saying to yourself every day, I am certain I can do this. I can recall what I need in the time that I need it. Own your moment and you will succeed. I hope this is helpful because what you need now is for your mind and your body to get on board with all of the work that you've been doing to prep for the time that you have coming. You've done everything you need. And now it's time to trust in the fact that you have committed to this journey. And now it's time for game day. I hope this is helpful.
Amazing, Meryl, amazingly helpful. And, the break that people needed. People definitely need a break from me for these long sessions. And you're just so calming and helpful. And I love what you talk about visualizing success and just taking care of business. I have this shirt that she gave me as part of her course that I wear all the time that says resilience junkie, like someone who's just, oh, you're wearing it right now. There you go. Yeah. Addicted to the next level, right? So yeah, for everyone here, this is just the next level. I mean, I say this all the time. This mountain is just a foothill to another mountain. You're going to pass this bar exam, and hopefully you'll realize, wow, I was able to pass this bar exam by pushing myself. And that same way I was able to push myself for that, I can push myself for the next thing, and it'll just be a snowball effect of success in your life. So Meryl, I'm so grateful to have you here. Does anyone have any questions for her at all about anything? And you're welcome to like stick around and chat with people in the group chat. That might be the most effective way to do it, honestly, so I can continue talking about the Constitution. But
you got it. I'll stay for a couple minutes, but here's the last thing that I want to say to you. I see some things in here, right? Like Scarlett saying having a panic attack the day before and not sleeping the night before. Scarlett, my question to you is, and this is one that you can all ask yourselves, regardless of the thoughts, the negative thoughts that are going through your head, what do you want instead? So instead of having a panic attack before and not sleeping the night before, what do you want instead? You want to have a great night's sleep. You want to be on your game. You want to be confident, secure in your answers, right? So you need to start to ask myself, if you hear that negativity coming in, ask yourself that one question: what do I want instead? Flip the script and make sure that you put your focus on what you want to happen, because wherever you put your focus is what you're going to get. So erase all of that and replace it with the positive energy that's going to put you in the right direction. I'm going to let you guys get back to the Constitution. I'll stick around for just a couple minutes more. I know we've got so much to cover, Andrew, so thank you for giving me just a moment to hopefully inspire you all. You got this. I can't wait to hear about your successes soon.
amazing, thank you. All right, well, that was probably the coolest commercial break in IBIS prep history. But if you also, Meryl, I know want to leave your information about yourself, your services, your course that's coming up, I think that they would love that. All right, cool. All right, you guys want to learn about the Florida Constitution? I'm gonna have to kind of fly through these subjects, but I think that's what you'll really want me to do at this point because, you guys want to get back to studying. So when it comes to the Constitution, there's three different lenses you should look at. There's the Florida lens, the federal lens, and the crim lens, meaning like, crim pro or potentially even criminal law. And you just have to be prepared to write strong essays using all of those three different lenses. The first one is the federal lens, standing, state action, justiciability, right? Like, is there state action? Is there causation, injury in fact, and redressability? And is it justiciable, meaning is it, not ripe? I mean, is it unripe or is it moot? Meaning, is it too early or is it too late? It has to have all these, perfect features for there to be constitutional considerations. The order of federal constitutional considerations and likelihood to be tested, I think, begins with the Fifth Amendment. On the Fifth Amendment, there's 5 different things. I've labeled them here: due process, the takings, the right against self-incrimination, and the Miranda rights. And sorry, I'm just gonna make sure that everyone's got their mics off. Sometimes I get a little feedback. Yeah. Okay. So, and the right against self-incrimination and double jeopardy. So those are the 5 things on the Fifth Amendment: due process, the takings, the right against self-incrimination, the Miranda rights, and double jeopardy. Again, this could be like a crim essay if it's talking about Miranda rights or double jeopardy or right against self-incrimination. It could just be a regular con law essay if it's talking about due process, and potentially even a real property essay if it's talking about the takings clause. Equal protection is tested a lot, and you got to recognize that in Florida, the suspect classes include race, alienage, national origin, and disability. And then also just remember other things that are subject to strict scrutiny, like the right to vote, the right to access courts, the right to be a candidate, the right to work, the right to privacy. All these things will trigger strict scrutiny, and recognize that strict scrutiny means that the government has to show that it's necessary to achieve a compelling government interest. Intermediate scrutiny means that it's substantially related to an important government interest, and rational basis means it's reasonably related to a legitimate government interest. So, try to address whose rights are being impacted here and what level of scrutiny will apply. This concept right here about the First Amendment, I mean, it could be a whole essay about this, about like freedom of speech, and if it's a public forum or whatever it may be. This part right here took me more time researching than any part of this essay. In fact, it was the part I almost wanted to quit. I had to research out the wahoo to do this. So I'll read it out loud and just know that this is all from research, not to be argued from me, because this is not like one of the things that I just wrote from the back of my head. This is something I had to really research and come up with, and I'll read it aloud to you. And if it's tested, you'll be very happy that I mentioned this. To evaluate a governmental restriction on speech occurring on public property, courts must determine how the regulated area fits into the following categories of forums: traditional public forums, designated public forums, limited public forums, and non-public forums. A traditional public forum, like a sidewalk or a park, is subject to time, place, and manner, content-neutral restrictions, which are a heightened level of intermediate scrutiny. A designated public forum, like a university auditorium or municipal theater used for expressive activity by the public, is subject to the same restrictions as traditional public forums, but only while holding itself out as a public forum during that designated time. A limited public forum, like public school facilities open after school or the interior of a city hall, a forum that's open for expressive activities but with restrictions to access based on subject matter and or speaker. It must be viewpoint neutral. Viewpoint neutral is less stringent standard than content neutral, because the content of discussion can be restricted to abortion, for example, but the viewpoint, pro or anti, cannot be restricted. And then non-public forums like prisons, military bases, interior polling places, mailbox of public school employees, airports, the government has much more flexibility to limit speech so long as the restrictions are reasonable and viewpoint neutral. So that's kind of like the hierarchy. Like traditional public forum is the, content neutral. Designated public forum is still content neutral. Limited public forum is viewpoint neutral. And then non-public forum is viewpoint neutral, and, they can pretty much restrict in reasonable ways. That's a tough piece. So if that went over your head, don't worry. It went over a lot of people's head, even mine. It was very hard for me to understand that. All right, unprotected speech includes hate speech, words likely to incite imminent loss activity, obscenity, false or misleading commercial speech, and defamation. Obscenity appears to the prurient interest of humanity and is devoid of any social or artistic value. So despite what you may think about Andrea's album cover, it's not obscene because it's certainly artistic. It literally teaches this point itself. All right, cool. So freedom of religion, right? Freedom of expression, and freedom of association and free exercise, right? Those are the freedom of religion clauses. Fundamental rights, Rand and Camper, race, alienage, national origin, disability, contraception, marriage, procreation, education, and right to raise your family. Additional fundamental rights is the key piece. Include the right to travel, the right to vote, the right to work and join a union, the right to privacy, the right to be a candidate, the right to be free from governmental takings, access to courts, procedural and substantive due process rights, the right to bear arms, the right against unreasonable searches and seizures, the right to counsel in certain circumstances, the right against self-incrimination, the right against double jeopardy, the right to a speedy trial, the right to confront witnesses, and the right to trial by jury in certain circumstances. I really fleshed that one out for you, right? Those are the fundamental rights in Florida. If you can think of another one, send it to my text message, but I sent a lot of them here, right? Right to vote, right to travel, right to work, right to privacy, right to be a candidate, access to courts. This is heavily tested, especially this part of the Kluger Doctrine. This is how I know I'm running laps around my competition, because every student that comes to me from another tutor has never heard of the Kluger Doctrine. It doesn't matter what program they did. But then if you look at the Florida essays, the Kluger Doctrine is literally mentioned on like 3 different model essays. So it's like, how can no one be teaching something that's literally been tested 3 times? That's crazy. So I'm going to teach it to y'all. The Florida Constitution guarantees that courts shall be open to every person for redress of any injury, and justice shall be administered without sale, denial, or delay. Be on the lookout for a law or ordinance that requires posting a bond, paying money in order to go to court, or a law that has a clause restricting options for seeking relief. While access to courts is a fundamental right subject to strict scrutiny, it's important to note that under the Kluger Doctrine, certain fundamental rights, including access to courts, can be restricted if there's an overarching public purpose. One potential example is restricting access to courts during a pandemic for health concerns. The Kluger Doctrine should always be mentioned to support a counter argument against an argument for denial of access to courts. So, right, some things, if you give a mouse a cookie, they're gonna want a glass of milk. If you mention access to courts, you should mention the Kluger Doctrine. It's just kind of like, you know, if you mention my legs, you should mention swap. I think this style of writing allows people to get more points and to, you know, do better on a test. So scrutiny levels, right? Strict scrutiny, intermediate, rational basis. Examples, you know, rational basis, age, wealth, teachers, garbage workers, for example. Rational basis with bite has been used when it can be shown that the government acted with animus toward the challenging party, and has usually been used by courts for cases involving discrimination based on sexual orientation. We talk about vagueness, meaning you don't know what's being punished. Over breadth, it's punishing more than it's supposed to. Separation of powers tested a lot, right? You got to know legislative, executive, and judicial functions and make sure there's no entanglement, entwinement, encroachment, usurpation, or any of these types of concepts. Takings in eminent domain, right? Under the Fifth Amendment, they cannot take private property for public use without just compensation. It can be possessory if it's physical, or regulatory if it, you know, satisfies the Penn Central multi-factor balancing test. Like there's, you know, the economic viability of the land, the owner's investment back expectations, and the, you know, diminution in value of the property. 10th versus 11th Amendment. 10th Amendment is state sovereignty. 11th Amendment is sovereign immunity. Make sure you know the difference between them. These things are more MBE stuff. Commerce Clause, right? The Congress can regulate the channels, instrumentalities, and economic activities that in the aggregate have a substantial effect on interstate commerce. Dormant Commerce Clause, you know, the negative implications of the Commerce Clause, that states cannot act legislation that discriminates against interstate commerce or unduly burdens interstate commerce. Privileges and Immunities Clause, meaning like they can't discriminate against out-of-staters. Anti-commandeering clause, the Congress can't force the state of Florida to enact legislation. Ex post facto law, this could be tested, right? Punishing someone retroactively. Contracts clause, you know, impairing private or public contracts. Let's read this one. Under the contracts clause, state regulation must not substantially impair a private contractual relationship unless the state has a significant and legitimate purpose behind the regulation, such as the remedying of a broad and general social or economic problem, and the law must be reasonable and appropriate for its intended purpose. A heightened level of scrutiny is applied for situations where laws modify the government's own public contractual obligations. Fair enough. Bill of attainder, that's punishing someone without trial, and double jeopardy, you know, punishing someone for the same crime twice. Conveniently, I also ranked the Florida common law issues in order of likelihood to appear on the essay. I really hooked it up for this imaginary stick boy. So sunshine law, I mean, for me, this is where I feel like this is coming. I feel like this is really coming on the Florida February 2025 bar exam. I already said, like, you know, maybe there could be a products liability. That's more of like hunch. This, I really have put together some pieces, and I feel like Florida common law is due. Again, study everything, but make sure, especially, you know, sunshine law, homestead exemption, and enacting law in Florida, types of law in Florida, home rule power, types of powers in Florida, special legislative session, separation of powers, constitutional officers, Kluger Doctrine, amendments to the Florida Constitution, defamation, express right to privacy, right to work, municipal bonds, excessive bail, taxation considerations, rights of convicted felons, pocket vetoes, advisory opinions, rules of judicial procedure, prohibited subject matters, original jurisdiction of the Supreme Court. That's Vicky VIP's album. Period. 23. Oh, that's why you did the Michael Jordan 23. No, that's just a coincidence. But anywho, those are 23 issues that you could really learn. But come on, it's only 4 pages of reading. You can literally read that the morning of the Florida bar exam. My goal is to have a poster, one of those little thingies, and it's going to have a QR code, and the QR code will give students access to my book and my Florida multiple choice Q bank. And I'm going to, you know, pass it around the hotels like Monday. And literally, I feel like I could save a lot of people. Why? Flip to this page and read this the day before the bar exam. This is some hot shit right here, right? So the sunshine law. Under the Florida Constitution, the sunshine law provides the public bodies are required to publicize all governmental activity and discourse. This law serves as a right of access for the people and ensures that legislation is conducted in the sun for all to see. There's an exception for unplanned meetings between two legislators, so long as one of them is not the governor. This law does not apply to private entities. A common unsuccessful defense to the Sunshine Law is the right to privacy, although the right of access in Florida will overcome this defense. It is still useful to mention this defense in an essay. The three basic requirements of the Sunshine Law are meetings of public boards or commissions must be open to the public, reasonable notice of such meetings must be given, and minutes of the meetings must be taken. So that's the Sunshine Law. Homestead exemption, right? It applies to half an acre inside a municipality, 160 contiguous acres outside a municipality. And this is that it protects against the forced sale of a person's primary residence from judgment creditors, except for property taxes and obligations contracted for the purchase, improvement, or repair of the house, such as construction liens, mechanic liens, mortgages, and homeowner association fees. So then this also talks about how a homestead will protect the spouse and minor child, that they can't devise it. And then the two deductions you could take for tax purposes and for the value of the home. This part's tested less than this part, the judgment creditors and the protection. Enacting law in Florida. I really feel like this is what's coming down the pipeline on Florida essays. They're going to give you an act or ordinance and you're going to have to say why it's not constitutional. Maybe it didn't conform with this. It must have clear title, single subject, enactment clause, be related to the health and welfare of the people of Florida, and not be vague or overbroad. In order to become a law, there must be bicameralism, approved in both the House of Representatives and the Senate. It must be read 3 times, and there must be presentment to the governor for signature. There's no pocket veto in Florida, so an unsigned bill that has been passed in both houses still becomes law. Be careful, as these procedures are necessary for passing laws in Florida, but not all rules and regulations, such as municipal ordinances, need to comply with the strict formalities of enacting a law, although they can never be vague or overbroad and must always survive constitutional muster. I had to write this part because my dog Joel, and I'm going to show you his outlines later, he wrote an essay, and I talked to him on the phone after, oh, how'd your essay go? And the thing that bothered me is he went so deep into enacting law in Florida, but when I looked at the prompt, I was like, this was like a library ordinance or something. This wasn't a Florida law. So like, remember, like, this is for laws, not for like, a public library policy or something. But again, when in doubt, write it out. Types of laws in Florida. Nobody knows this, right? Except for my students. General law, special law, general law of local application. And Grace actually sent me this cool article that I included in the classroom now that talks about like Dillon's rule and where the home rule power comes from and why this all exists. But who cares, right? Just write it on the essay. General law applies to the whole state uniformly. Special law applies to a special county and requires a referendum. And then general law of local application is going to be based on population. If you see one that looks like a general law of local application, maybe argue that it actually is a special law because they're attempting to circumvent the voting requirements. Like if it says all counties with population over X amount need to do this, and Dade County is the only county it applies to, maybe there's an argument that they're trying to circumvent their voting requirements. Home rule power is really an important vested power in Florida. It would allow municipalities to, enact their own legislation that does not conflict with the Florida legislators. That's why Miami can have laws about like spring break in Miami Beach or something. So types of counties in Florida: chartered versus non-chartered counties. Chartered counties have home rule power, where non-chartered counties are subject to general laws of the state of Florida. Special legislative session requires whatever the governor called it for, that's what they have to talk about. I feel like DeSantis just tried to call one recently or something. They can last for up to 20 days and are convened at the request of the governor by joint proclamation of the Speaker of the House and Senate President. Okay, so then we get kind of into the weeds a little bit, but separation of powers, very important. It's hard to recognize, but just be like, did someone who's a constitutional officer do something that they weren't allowed to do? Did they say that the mayor could decide guilt? That's not fair. Did they say that the governor could, create a law? That's not what he's allowed to do. This is a good piece I got from an essay, right? Nobody ever knew this, but this was the year I took the Florida bar, 2017, and this was in the model essay. They snapped on this model essay. Constitutional officers in Florida include the governor, the lieutenant governor, the CFO, the commissioner of agriculture, state attorneys, public defenders, sheriffs, tax collectors, property appraisers. That's what my family does. Gang. Supervisors, not for the government though. Never. Supervisors of elections, clerk of the circuit court, county commissioners, district court board members, and superintendent of schools. These officers have vested duties and must complete relevant ethics courses. Fair enough. Fluker doctrine we talked about, you can overcome access to courts to show a public necessity. Amendments to the Florida Constitution require at least 60% approval. If any of y'all lived in Florida, you either voted yes or no to abortion and marijuana. They both got over 50%, but neither were approved because they didn't get 60%, because those were trying to make amendments. Defamation can be slander or libel. Defamation of a public figure requires actual malice. Defamation is not protected by the First Amendment. Honestly, I don't really know about those marijuana and abortion things, whether they're amendments or not. I just do know it had to be 60%, but I try not to pay attention to anything except when I'm doing. So express right to I don't pay attention to the real world, only like the testing world. Express right to privacy. The Florida Constitution states every natural person has the right to be let alone and free from governmental intrusion into her private life, except as otherwise provided herein. This section shall not be construed to limit the public's right to access public records as means provided by law. That's why the Sunshine Law defeats the right to privacy. So we have a very important right to privacy in Florida. Right to work is fundamental. Municipal bonds, if you want to learn about municipal bonds, hire me to teach you for the Series 7, Series 66. I was supposed to do a whole course for this one, let's call them a broker-dealer company, Mass Mutual, but they flaked on me. I guess my numbers were too big for them, but I was going to teach their agents how to pass a Series 7, but they'd rather them just be unlicensed and unequipped, but whatever, can't change the past. So anywho, if you want to learn more about municipal bonds, I could teach you in my Series 7 world, but like all you need to know for the bar exam is the simplest concept, that there's general obligation bonds and then there's revenue bonds. General obligation bonds are paid by taxes and subject to a vote referendum. Revenue bonds are paid back by the actual revenue of the project. So a GO bond would be like a park or a public school, right? A rev bond would be like a toll bridge or an airport. So, you know, rev bonds, GO bonds, let's get it. Excessive bail, under the 8th Amendment, you have to have unreasonable danger from the criminal defendant. The 8th Amendment, you know, cruel and unusual punishment. Taxation considerations. It's important to note that ad valorem taxes are levied by counties and municipalities, not the state. So look for the state trying to levy a tax. That's not going to be appropriate. That's a county thing. I pay taxes on my little property here in Dade, a shit ton of taxes. Rights of convicted felons. A person who has been convicted of a felony is not eligible in Florida unless they've had their vote restored. I mean, if they give you an essay on voting restoration, that would be absolutely crazy. But just know that, you know, they don't have their right to vote unless it's been restored. Pocket veto, unlike federal law, the governor cannot do a pocket veto. Advisory opinions, unlike federal law, the Supreme Court can do an advisory opinion. Rules of judicial procedure, you know, pretty solid stuff. Prohibited subject matter, things that the general laws of local application cannot cover, right? It has to be general. Taxation, elections, petite juries, conditions precedent to bringing civil or criminal claims, venue rules and rules of evidence. And then original jurisdiction of the Florida Supreme Court, that's one of Victoria's albums, right? Like, you know, they got original jurisdiction over bond validation proceedings, imposition of the death penalty, invalidation of a statute or constitutional provision. Finally, I've ranked the most common issues tested on crim law essay. So 4th Amendment, right against unreasonable search and seizures, right? 4th Amendment, you know, unreasonable search and seizures, sure enough. 5th Amendment, custody, interrogation, Miranda rights, what the fuck? And things like that. 6th Amendment, right to counsel. So what's the difference between 5th Amendment, 6th Amendment, right to counsel? 5th Amendment right to counsel is before charges have been filed. 6th Amendment is after charges have been filed, right? Exclusionary rule, anything that's found in violation of constitutional rights will be excluded. Fruit of the poisonous tree doctrine, anything that comes after that will also be excluded. Warrant requirements by an impartial judge has to name the person being searched, description of items and premises searched, person of items are to be seized, communication be intercepted, and probable cause justifying the warrant. The searches, the exceptions to the warrant requirement, I like the mnemonic spaces: search incident to arrest, plain view doctrine, automobile exception, consent, exigent circumstances or hot pursuit, stop and frisk doctrine, right? These are all things that, you know, space is a really good mnemonic. Terry stop, little stop and frisk action, reasonable expectation of privacy, trash can inside your home, but not on the sidewalk. Stand your ground laws, right? You're allowed to, you know, protect yourself and protect your home under the castle doctrine. Impermissibly suggestive lineups, right? They can't have a lineup that you know, we're accusing Muggsy Bogues of a crime and we line them up next to Shaq, Yao Ming, and Victor Wembanyama or whatever. Wembananas. I don't know how to say this dude's name. I'm too old. All right, so you get it though, because Muggsy Bogues is really short and they're really tall, and it'll be obviously they're gonna pick him if the guy was supposed to be short. That's the point of an impermissibly suggested lineup. Victor Wembanyama? All right. Anywho, crimes are like robbery, conspiracy, burglary, murder. I wrote a lot about murder on this. Murder can be tested in criminal procedure or on an essay potentially, but not likely on an essay. Just know that first, second, and third degree murder are all recognized in Florida. Florida recognizes first degree murder as, you know, common law, malice aforethought, premeditated murder, or enumerated felony murder. Depraved heart murder, intent to inflict great bodily harm, those are second degree murder. And then third degree murder is a non-violent felony. So like you know, like maybe a kidnapping or a burglary or something that leads to murder, or like theft of an aircraft or something. Defenses to murder: excusable homicide, justified homicide, self-defense, stand your ground law. A person who is attacked has no duty to retreat and has the right to stand their ground and meet force with force, including deadly force, if it's reasonably believed necessary to prevent death or great bodily harm, or to prevent the commission of a forcible felony, right? These are the arguments that they were made in the Trayvon Martin case. All right, then manslaughter, you know, voluntary versus involuntary. Voluntary is adequate provocation or imperfect self-defense. Involuntary manslaughter is like you know, driving while texting and killing someone. Florida recognizes these theft crimes: arson, attempt, solicitation, vehicular homicide. I know this was an extremely long letter, but that's common law for you in a nutshell, right? Florida lens, federal lens, and con crim lens. Takes us to real property. Super tough subject. What I did for everyone, actually, I had my February 2024 class, so just a year ago, I put them to work. So you should be grateful. The work of your class a year ago gave you all this, which is just like all of the major vocabulary words that I was able to think of when I was sitting in the sauna one day. And I think that they are defined, and, you know, it can't hurt to know them all, right? It really can't hurt to at least know what all these words mean, right? Honestly, in 2026, 2025, I could have had ChatGPT do this. I could have been like, yo, ChatGPT, these are all the words and these are all the definitions. I'm not sure who would have done better, a class of students or ChatGPT. They both have their flaws, but, you know, this is a general vocabulary list that was made by students. I even say it in the essay, like, don't blame me if there's little blue lines here, but like, yeah, these are some really important words that you can go over, memorize, and make sure that you understand and master. And again, I have read over them. They're all correct. They're just not written as eloquently as I would like, nor were they made by a robot. They were made by actual students who are like, you know, representative. Okay, so then I talk about real property. So real property blueprints. So the story of Stickacre, right? The what happened here? Florida's a lien theory state, which means that a JTROS will not be severed by a mortgage, and if one party dies, then the lender cannot recover from that party. Florida is a, you know, from the property. Florida's a pure notice jurisdiction, which protects bona fide purchasers. Bona fide purchasers take for value in good faith without notice. Notice can be actual inquiry or record, right? Constructive notice. So, you know, talk about lien theory, talk about pure notice jurisdiction, talk about the waste doctrines, whether waste was committed, actual, which is also known as affirmative, also known as voluntary waste, or permissive waste, letting the thing rot, or ameliorative waste, which is tested a lot. This is for life estate tenants and for tenants of a landlord-tenant contract. They test this a lot, JTROS, right? For unities of time, title, interest, and possession. Tenancy by entireties, JTRS post marriage. Florida does not require a straw man. And then, you know, you could seek a partition potentially, but remember, remainder men cannot seek a partition. You can only seek a partition when you have vested, when your rights have vested in the property. A mortgage, a loan secured by property, foreclosure, for sale of the property, deficiency judgment, when the sale of the property is not enough to pay back the mortgagee. A PMM, a purchase money mortgage, is when the money is used to buy the property and they have the highest priority. Expressly assumed, subject to, these are more MBE terms, but you still want to rock with them if you can on an essay. Equitable right of redemption is before the sale of the house you could buy back potentially, and statutory right of redemption would be after the sale of the property potentially. Due on sale clause, acceleration clause, no early prepayment clause, equitable mortgage, deed in lieu of foreclosure. You know, you can read through this if you want to learn more about mortgages. Easements are tested a lot, different types of easements: express easement, implied easement, easement in gross, easement pertinent, easement by prescription, easement by necessity, affirmative easement, and negative easement. The time period for acquiring a prescriptive easement in Florida is 20 years. A prescriptive easement does not require exclusivity, but otherwise has the same elements as adverse possession: open, continuous, adverse, notorious, hostile for the statutory period. Florida does not recognize a negative easement for light or air under Flat and Blue versus Eden Rock, but most jurisdictions in Florida have riparian rights or water rights. So a plausible argument against the existence of the easement is that only a license is created. A license is a revocable use in property, where an easement is a non-possessory use of property. So easements are, you know, you actually own it. Even though it's non-possessory, it endures, where a license can be freely revoked. So remember, the proper remedy for misuse or overuse of an easement is not termination, but a surcharge or some sort of injunctive to get them to stop. Real covenants are remedied by monetary relief. Equitable servitudes are remedied by injunctive relief. Stick acre could be acquired by adverse possession. Adverse possession, open, continuous, exclusive, adverse, notorious for the statutory period, which is 7 years in Florida. So remember, 20 years for prescriptive easement in Florida, 7 years for adverse possession in Florida. You could have tacking. Color of title means appearance of title, like a defective deed or something. If you don't have color of title, then you have to have actually paid the taxes on the property in order to claim adverse possession. We talked about homestead a lot. It's got to be half an acre inside municipality or 160 contiguous acres outside municipality. This is the primary residence, protected from outside creditors, and things like that. I mean, they could talk about rule against perpetuities. No interest in land is valid unless it must vest, if at all, within 21 years of the death of a life and being at a time the interest was created, or actually vest within 1,000 years in Florida, right? That's like, if you're writing about rap, I mean, okay, Kendrick Lamar, do your thing. Larry versus Tommy leasehold issues. You see, I've been rocking with Larry and Tommy for a while now. I feel like those are just like the least offensive names. Tend not to have any students with those names either. So habitability, quiet enjoyment, right? Make sure you talk about that. Constructive eviction, meaning like, okay, you made it so inhabitable that I got to move out, but I have to give notice. You got to pay rent, avoid waste. Remember, your period will suffer. Just a side note, this is a mnemonic, not an acronym. Examples of acronyms are USA, FBI, and the IRS. Just a side note that both you and I, Stick Boy, should consider ourselves fortunate that this particular mnemonic does not resonate deeply with us. Your period will suffer. I am hilarious, right? But I really did want to teach. I love teaching. There's a difference between mnemonic and acronym. Now you all know what it is. Okay. Anywho, tenancy for years, periodic tenancy, tenancy at will, tenancy at severance. Your period will suffer. I actually really like this mnemonic because it's one of the few where it's like not hard to remember what it stands for. Your is years, that one's kind of hard, but then period, periodic, easy, will, easy, sufferance, easy. So it's a really good mnemonic in terms of like, it matches up. 60-day notice for residential periodic tenancies, 90-day notice for non-residential for year to year, 30-day notice for residential, and 45-day notice for non-residential for quarter to quarter. Month to month is 15 days for both, and week to week is 7 days notice for both. Types of non-residential leases include commercial and industrial leases. Cool. In summary, you may very well get an essay where Larry the landlord is fighting with Tommy the tenant. Remember that Larry has the duties of habitability and quiet enjoyment, and Tommy needs to pay rent and not commit waste. That's pretty simply put. Now we have a love story between the contract and the deed. Why do I call it a love story? Because the contract merges with the deed, you know, love, right? So land sale contracts, they're very likely to test, in my opinion, this administration. And I don't mean very likely, let me retract that. They could test this administration, an essay that combines real property and contracts. Because if you think about it, you know, contracts, real property are the same subject. It's just, you know, UCC or, you know, real property law, but it's the same contracts. So it's got to be in writing, right? Conform to the statute of frauds. It's got to describe the property to be sold, and all these different factors, right? They have a duty to disclose. That's a Johnson v. Davis. That's a landmark Florida case. Some landmark Florida cases: Johnson v. Davis, duty to disclose latent defects in a residential real property. Fountain Blue versus Eden Rock, there's no right to a view. The Kluger versus White, that there's, you know, a right of access to courts could be restricted if there's an overarching public necessity. Those are some of the major cases to know. Do you have to know cases to pass the Florida bar? Absolutely not. If you drop a case in there, I mean, are you the man? Probably, right? All right, or the woman or the non-binary, right? Duty to disclose known defects, etc. As is clause, general disclaimer with all faults, right? Does not absolve a seller of liability in residential real property, in main commercial property, but a specific disclaimer like seller makes no warranties on the condition of the roof will likely be effective even in residential property sales. Sure enough, they can write a whole essay about concealment, misrepresentation, puffery, which I think is a hilarious word, like exaggeration of material facts, like I'm sure I do a little puffery in my day. A title free from any claims or disputes from the ownership or from any threat of litigation would make it unmarketable, right? So marketable title. Equitable conversion means that during the period of escrow, after the contract is signed, but before the closing, then the risk of loss will pass to the buyer. It also means that the buyer or the seller, if either of them are to die, their estate will still have to go through with the sale after the contract's been signed. It's important to note that the land sale contract will merge into the deed, and once the deed is recorded, the buyer and the seller will forfeit any lingering claims related to the contract. If there are any conflicting terms between the contract and the deed, then the terms of the deed will prevail. The deed is a legal instrument that grants title to the owner, and proper recording should put others on notice, whereas title is a legal ownership in the abstract sense. The deed is the written form that gives ownership. For instance, you could have title via adverse possession and still not have a deed. Deed formalities, signed, written, attested by two witnesses, accurate description of the land, special warranty deed, general warranty deed, and quitclaim deed. Remember, I said this is a major point, not for any reason, just it's like the amount of mastery that's necessary. You know, I don't believe in this minimum competency test. I don't believe in a lot of the food. I'm not eating a lot of the food that's being cooked out there. And I think that's something you'll probably learn about me that I believe. Like, I'll be the first one to tell you, I went to Starbucks the other day and I'm like, this shit is prison food. Like, this is the worst breakfast I could ever have. There's no fresh fruits here. They're squeezing, you know, something out of like a ketchup bottle into a drink and charging me $8 for it. That's wild. I'd rather go to like Chandler's. I'd rather go to Fuzbee's. I'd rather go to The Last Carrot, right? These are 3 organic places in the Grove that actually serve legitimate natural foods. Like, that's not crazy. I don't like McDonald's. I don't like Burger King. I like, you know, shit that tastes good. Like, I'm sorry. They're serving you McDonald's and Burger Kings out there. I always tell people like, oh, you know what? I'll put this on YouTube. I'm not too, I don't care. You know, Kaplan Barbary Themis, that's McDonald's, Burger King, and Wendy's, right? That's Quiznos, Subway, and Jimmy John's. What I'm cooking here, homegrown from the farm, organic, you know, these are the things you need, right? So the reason I'm talking about this right now is because that's the level of mastery I need my students to be at. I don't know if they're going to test this or not, but I need to be able to ask a student, hey, Andrew, am I ready to pass the bar exam? I've never met you before in my life. How will I know? Okay, first off, you're gonna need to pay me $1,000. Second off, I'm gonna ask you one question, right? Like Rick Rubin, that's what he does. Yeah, it's a good song, Pay Me $1 Million. I'm gonna ask you one question. What are the 6 warranties of a general warranty deed? If you could spit them off, yeah, I feel like that's a really good indicator that you have the level of mastery at this test. If that's a stumbly and bumbly thing for you, well, that indicates a lot of stumbliness and bumbliness around the entire exam. And like, this isn't something that you haven't seen. Barbary, Kaplan, Themis, you know, Quimby, you know, Studicata, everyone and their mom has this on their outline. So if you don't know this, it's problematic, right? So I'm saying like you should know this and you should know everything of this difficulty. That's what this test is. That's what we're cooking from the farm, right? You know, the McDonald's server might tell you don't need to know this that well, but I'm telling you, yeah, you actually do. And I want you to pass this test and leave no doubt. So general warranty deed has the warranties of size and right to convey, encumbrance, and the covenant against encumbrances. Whereas those are the present warranties. The future warranties are general warranties, further assurances, and quiet enjoyment, right? So present, future warranties, you should be able to talk about them. Quiet title, that's an action to be like, if there's conflicting, you know, claims to property, we're gonna have an action to quiet title to determine who has superior title. All right, that's the big 4, right? Those are the big 4 essays. Family law is super easy. JVPs with a side of mustard, right? Jurisdiction, venue, parenting plan, equitable distribution, alimony, child support, esquire fees, dissolution, and modification. I don't know why this dude Jeremy, when he taught this, he used to work for me too. called it with a side of mustard. And I didn't like it at all until DJ Mustard became famous for yelling mustard, or Kendrick Lamar or whatever. Now I like it. Now I don't forget it. So JV piece with a side of mustard, meaning jurisdiction, venue, parenting plan, equidistribution, alimony, child support, esquire fees, divorce, dissolution, marriage, and modification. These are some of the main pieces. Talk about the UCC, JEA, talk about venue, where one of the spouses resides, where the marriage last existed, where the breach that caused the split occurred, right? Where Tommy found Susie with the pool boy, right? It's probably in Miami Beach. The parenting plan, best interest of the child. You can do a split parenting plan, ultimate parenting plan, or sole parenting plan. I also hear this called dynamic, meaning like Tommy does sports, Susie does math, right? Split, is the presumption. Sole is only when, the dad, probably the dad, but maybe the mom, but probably the dad is a total fuck up and they have to take them away for the danger of the child. You have a constitutional right to the upbringing of your child. So this is very rare to be awarded sole parenting. We use the word time sharing instead of custody, but you can use the word custody on your essay. You could still do fine. Equitable distribution, we're marital property state. So we, marital property, non-marital property, figure out what's non-marital property, and then the marital property will be divided equitably, right? Alimony, temporary, pendente lite, rehabilitated, bridge the gap, and durational. Florida has abolished permanent alimony, but if you already received it, you will be grandfathered in. Child support, best interest of the child, statutory deviations, 5%, 20%, these types of things. Esquire fees, attorney's fees may be awarded in family law matters based on need and ability to pay. Contingency fees are not allowable for domestic disputes. That's a key piece. And then dissolution, Florida, like every fucking state, is a no-fault divorce state. So it needs to be irretrievably broken or someone's mentally incompetent for 3 years or more. I beg, this would be a hilarious thing to allege if it wasn't true, if you just hated your partner so much, and then they're like, that's not true, and then the guy, fine, it's irretrievably broken. I just want to see if I could slip that one in there because I hate you so much. But it's not funny, actually. There are people who are mentally incompetent for 3 or more years, and that would be valid reason for divorce. Anywho, modification, upon a showing of substantial material change of circumstances, either party may petition for a modification. It no longer requires the change to be unanticipated, right? They also no longer require the 50-mile rule. So anytime a spouse moves with children, he, she, the non-binary person may be required to petition to the court, right? Okay, so additional family law topics, prenups, right? You gotta get that prenup. They're gonna have you for 18 years. For 18 years. Right, prenup, get that. Postnup, if you don't get the prenup, you should try to get the postnup. It's probably a little bit harder. Adoptions, right? You adopt a child, it's like the same as if you have a child. I'm not sure if you're planning or married or planning to have a child, but maybe advice is seek a prenuptial agreement before marriage. See, I gave this imaginary stick some good advice. I'm sure he didn't take advantage of that. Neither of my brothers got prenups. They just love their wives and trust that it's gonna all go well. And I do too. I think they have good wives. I think they pick good ones. Me, I'm still skeptical about who should be my wife. All right, ethics. Remember, when you're sitting at the bar exam and you're sitting there and this dude's sneezing his ass off, this girl's crying, someone is flatulating, another person is like freaking out because their computer doesn't work, and everything's going crazy around you, and then someone gets on the microphone, they're like, you will now have 15 minutes to sit there and contemplate life. Like, you're going to be sitting there and you're going to be annoyed. I would just be firing off rule statements that are most likely to be most likely going to be required to convey, and I would be articulating them in my mind exactly how I'm going to write them. So once the test starts, I'm just, oh, there's ethics, perfect, I'm writing this out immediately. Oh, there's contracts, what are the damages? I'm writing my damages section out. Like, I think that, for me, it's different. Giving myself advice and giving other people advice is not the same thing, and that's why I'm pretty, experienced at what I do. I've worked with all different types of people. And if you come to my classes, you see I have patience for all different types of people. I mean, it made me pause a little bit because I had to think about how much patience I have. But like, I work with all different types of people. For me, I have a way of doing things. For y'all, the general majority of y'all, you're too slow. You don't write enough words. You need more time. You don't have more time. So how do we account for that? Get to the writing, right? Like, stop reading the essay like you're a freaking detective and you're considering every word. Just be like, to quote Kendrick Lamar, I'm doing a lot of Kendrick quoting, bing bop, boom bop, bing bop, bam. Like, just write to it. Like, oh shit, this is negligence. duty, breach, causation, damage. Let's just start writing it out. Like, get the things on the paper instead of like, making arguments in your head. You don't get points for arguments made in your head. You get points for what's written on paper. So like, just get to the writing as quick as possible. Obviously, write the right shit, don't be writing nonsense, but like, don't take too long thinking. You don't get points for thinking. You get points for what you've written. So try to write as much as possible. And if you're sitting there before the test and you're, it used to be commercial paper, there was something you had to memorize. You don't even have to do that anymore. They made this test a little bit easier for y'all. So with that being said, just memorize like the ethics piece. I would be sitting there. I'm not looking at anyone. I don't care how hard they're sneezing. I don't care if they're like, yo, Andrew, don't you remember me from like 3rd grade? Like, nah, bro, I don't remember you. I'm doing this thing in my head right now, right? Like, that's literally how I am. That's why I'm an asshole, right? I'll literally say that to someone I've met. Someone I would have known this person for 35 years. I'll look them dead in the eye and be like, I have no idea who you are. And then look right back and just start memorizing. Because to me, I have a mission to do. Like, this is what's important to me. And then after the test, I see him at the bar. I'm like, yo, Johnny, I was just fucking with you, bro. But like, you get it. And I'm like, no, that was really fucked up. I'm like, all right, well, you're just not built like me. I'm sorry. Didn't mean to offend you, but I could care less, right? Okay, so these are the ethical duties. And this is how I start every single ethics essay. The ethical duties of Florida lawyers are outlined in the decisions of the Florida Supreme Court, the Florida Rules of Professional Responsibility, the ideals and goals of professionalism, the oath of admission to the Florida Bar, the creed of the Florida Bar, and other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. The possible consequences for failure to comply with these ethical duties are suspension, expulsion, and admonishment. If I go right down to the bottom, you'll see it. Oh, that's so sweet. 1997, Dear Scooby Drew. That's what my grandpa does, a little nickname for me. And my grandma always said that, be a good person. Rest in peace to my grandma. Fucking love her, right? Okay, so anyway, the ethical duties of Florida lawyers are outlined in the decisions of the Florida Supreme Court, the Florida Rules of Professional Responsibility, the ideals and goals of professionalism, the oath of admission to the Florida Bar, the creed of the Florida Bar, and other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. The possible consequences for failure to comply with these ethical duties are suspension, expulsion, and admonishment. I'm going to say it one more time. If you've been in my course about 100 times, you heard it. I want this written word for word on your essay. The ethical duties of Florida lawyers are outlined in the decisions of the Florida Supreme Court, the Florida Rules of Professional Responsibility, the ideals and goals of professionalism, the oath of admission to the Florida Bar, the creed of the Florida Bar, and other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. The possible consequences for failure to comply with these ethical duties are suspension, expulsion, and admonishment. You dropped that on your, ethics essay. Last administration, they tested ethics 3 times. My students were like, yo, I wrote that shit down, copied and pasted it in all 3 of my essays, right? For Vicky VIP, that's kind of a disadvantage because you won't be able to copy and paste because you're doing the blue book of life. But just write fast. Vicky does have an advantage though. She's ambidextrous because, as I learned today, and I love learning, in Italian culture, they frowned upon left-handed people and forced them to become right-handed. So Vicky, as a child, was forced to learn to be right-handed, never knew that it would come in handy, get it, handy, until today, or Tuesday, when she's gonna have to write, and when her right arm gets tired, she can pull out the left hand and start writing. That's pretty cool. So at least you have that in your toolbox. But anyway, let's talk about ethics. Ethics, we have duty of confidentiality. It's broader than the attorney-client privilege. Be ready for that. Duty of competence. Don't be an idiot, right? You can't, take on a case that you're not ready to do. I have an attorney friend of mine. She just may have violated this duty of competence, but luckily she's a supermodel. And instead of getting disciplined, she got asked out on a date by opposing counsel. Duty of candor. A lawyer may not knowingly make a false statement of material fact. I mean, she didn't do anything wrong. It wouldn't have been her. Let's please say that. It would have been her supervisor who was going on maternity leave and told her to read something off a paper. And then the judge asked for more than what was on the paper. And, she stuttered a little bit. And the judge was like, what, is this your first time? And she's like, yeah. And he's like, what the fuck? And then opposing counsel was like, hey, girl, what's your name? What's your sign? Right? Okay, anyway, duty of candor. A lawyer may not knowingly make a false statement of material fact or law to a tribunal, fail to disclose a material fact to a tribunal when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, or knowingly offer false evidence. Lawyers should refrain from filing frivolous lawsuits and should timely respond to all judicial requests. So we got duty of confidentiality, duty of competence, duty of candor, right? Duty of decorum. All Florida lawyers agree to uphold the standards of honor, integrity, and fair play and a cohesive commitment to equal justice, under the law and to the public good. Lawyers should show respect toward others, including opposing counsel and members of the court. So conflict of interest. With respect to former clients, an attorney cannot represent a new client in a case in which an old client will be adversely affected without consent from the former client, and the attorney cannot disclose confidential material in order to disadvantage the former client. So you have conflicts of interest with former clients, prospective clients. This conflict of interest can be imputed to the rest of the firm unless they're timely screened out. I try to put in bold the key buzzwords. Attorney's fees permitted by statute, rule, or sanction. They must be reasonable and are considered clearly excessive when they're overarching and unconscionable. Duty not to commingle. You got to keep the accounts separate. Contingency fees. So a type of payment arrangement where the lawyer only gets paid if the client prevails in litigation. Contingency fees are not allowable in domestic relations or criminal cases. They must be in writing and include a description of the fee and how it be calculated before a final disbursement is made. Referral fees are not ethical unless the amount is divided proportionally to the work performed, and there must be a written agreement with the client advising the joint representation, detailing how the joint representation will be conducted. Overall, when it comes to contingency fees, referral fees, these things, the client needs informed consent and you should get it in writing. That's like the safe harbor approach. Interest in client property, right? They need informed consent. Advertisements can't be false or misleading. Solicitation, right? You can, you can solicit accident victims, but you have to give them 30 days wait period. So rules of private practice, UPC, unpracticed, or UPL, right? Unpracticed law or unauthorized practice of law, right? I have a student who got accused of that recently. It's not good. Sale of a law practice, right? You have to sell the entire practice. Mediation versus arbitration. Mediation means that, they'll decide and you guys can agree or not. Arbitration means it's binding on the parties. You see arbitration in like baseball disputes for like, Clayton Kershaw or something. And one more time for good measure. The ethical duties of Florida lawyers are outlined in decisions of Florida Supreme Court, the Florida rules of professional responsibility, the ideals and goals of professionalism, the oath of admission to the Florida bar, the creed of the Florida bar, and other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. The possible consequences for failure to comply with these ethical duties are suspension, expulsion, and admonishment. So that's the end of my book right there. Those are the essay subjects. When it comes to my course and my materials, I added Grace's completed questionnaires. Grace is super solid at this. She's been working on these questionnaires. They're amazing. And then I have the blank questionnaires. I prefer you pull out the blank questionnaires and just be like, okay, shit, property questionnaire, pull it out. Have your boyfriend, your girlfriend, your side piece ask you, hey, Tommy, is Florida a lien theory state or a title theory state? What does that mean? Oh, well, Florida's a lien theory state, and that means that encumbrance on the property will not sever JTROS. And if the party who takes out the mortgage on the property dies, then the lender cannot recover from the other party based on the mortgage on the property. Oh, wow, that's amazing. Maybe your side piece will turn into your main squeeze if they see how good you are at answering these questions, right? So I really encourage everyone to go over these questionnaires. Even before I wrote my essay guidebook, even before I was teaching my ass off about this shit, I came up with these questionnaires, and that helped people in and of itself pass this test because it organizes the issues you need and allows people to articulate them ahead of time and then repeat that on test day. So I'm really keen on the questionnaires. Obviously, when it comes to Florida multiple choice, and I'm going to hopefully have the QR code that people can access this on, the last day. Listen, if you can't go to sleep the night before the Florida bar exam, you should definitely do my Florida bar exam Q&A with explanations, and you can go right through it, and it would be amazing because there's so many great questions and things that you could do that will lead to success on test day, right? First and foremost, I recommend the FBBE questions. These are questions that are written by the Florida Board of Bar Examiners, and if you go through them all, then you should be pretty set in terms of preparing more than others. I required students in my class to do this test 3 times. And those of you who submitted 3 times, I noticed that by the 3rd time, y'all were getting damn near 100%. Isn't that crazy what it takes? Mastery is a result of repetition. This final exam, right? You can see I took it 100%. That means I've gone over every single question and verified that this shit is true and accurate. I put little fire emojis in here. I wrote this exam and I would have gone over it. I would have taken time to go over it, but there were no issues, right? Nobody said a single thing. They said that every question was good. They understood why the wrong answer was wrong and the right answer was right. So like y'all could take the time to go through these by yourselves and learn from it. I do think this is the best practice exam for Florida multiple choice on earth by far right now. And this is brand new as of 3 days ago. So this is one of the, the FBB wasn't ready for this. When I created this, they didn't know that this was going to be out there for students to prepare with. So, I highly encourage you to do what I'd be, not afraid to do. Oh shit. Which I would not be afraid to do, which is go back up to the top, retake this quiz, start from square one, right? I mean, this seems to be a crime fraud exception. Boom, we're already 1 for 1. I would do it again and get to the point of mastery. But this FBB practice question, these are the disclosed questions. I have the final exam. I have, there's an area you suck at, go through it. And I really recommend doing these practice questions just for confidence sake and just to like, calm yourself down like over the next couple of days. It's something that could really help reinforce. Another thing that I highly recommend when it comes to Florida multiple choice are these materials that I kind of tucked at the bottom of the course, review materials, right? I have colorful Florida review materials. This was made by a student of mine named Hannah. And right, she like, puts everything in super colorful, coordinated, places. And Hannah crushed the Florida bar exam. So you can assure yourself that those are really solid. I really recommend student made materials from Barbara. So Barbara's outlines, she has really great outlines, MBE, Florida for civil procedure and criminal procedure. She got, I think, a perfect score on those subjects on procedure. Joel got like a perfect score on business entities. His outlines are fire. So you go to this, drive, pick up one of Joel's outlines. Obviously, Joel did an album cover because winners do album covers, but whatever. Y'all are all winners here. And he, crushed these outlines. So you could go to his, business entities outline and, comb it over from top to bottom and be like, yo, this is someone who got a perfect score and this is his outline. I could feel pretty confident, right? Amy's a tutor of mine, former student of mine, and her sister is a former student of mine, now a tutor of mine. And she has these amazing charts like Crim Pro time to do shit. And it's like all the time you have to do shit for the trial. She could only take on one student. This administration couldn't really be of much service because she's working her ass off as a practicing attorney at her father's law firm. That's what happens, right? So like, she's a great student. She got a 163 on the bar exam. Amy had failed the bar exam 3 or 4 times before she came to me and then got a 163 after one administration with me. So it's like, I really believe I'm really eating what I'm cooking here. Imagine that a student who had failed it 4 times, their odds of passing on the 5th time statistically is very low. Like I would never bet on that student if I didn't have my hands on them. And then she scored a 163 and now is not only a tutor, a top tutor, and her materials are so good that I had her come and teach. And she did these videos, right? She's really good at evidence. She has this hearsay thing, right? I highly recommend you go through, her Florida PowerPoints for evidence. They're really good, really, really thorough. And I'm a huge proponent of Florida multiple choice. Like it's half the battle. So Amy's outlines are amazing. Amy has videos. Amy has outlines. Amy has study materials. I highly recommend jumping into them. Also, my man, Jacob Jingleheimer Smith, right? Another dude who made an album cover. Tends to be a correlation between people who enjoy doing this, enjoy the process, and then go out and take care of business, but to each their own. So Jacob has a outline. It's like a 75-page outline. Like, my essay guidebook is 75 pages. This is an 81-page outline, but he does every single subject, right? Like we could talk about some of these things, first appearance within 24 hours of arrest. The non-adversarial one has to be within 48 hours, but they can get 2 24-hour extensions. The adversarial one has to be within 21 days. And that's when they're not under custody. Then we have the, formal charges have to be 30 days plus 3 of the event, but you could get the 3-day extension or the 7-day extension. So up to 40 days, right? Like all these little dates and times we have tucked away in these outlines. And like, I don't know, maybe you rock with Barbara, maybe you rock with Joelle, maybe you rock with anyone, but these are outlines that I've given you all that could really, really help you. The essay questionnaires blank, they're in there for sure. I have all my recordings from July 2024. I have all my essay workshops from previous years. I have my February 2024 recordings. I mean, there's so much in here that if you're feeling, uneasy, then you can just dive in and learn a lot. And I'd say, without a doubt, the places that I'd spend a lot of time are my essay guidebook. I mean, that's just a really condensed way of absorbing the essays. And then these Florida Bar Q&A explanations. I mean, they're just practice questions that I think will be similar to the ones that you'll see on test day. On top of that, I dive into the outlines and things like that. Definitely, for sure. I just want to go over, some of the multiple choice subjects and give you some key pieces to talk about. I have a student who's coming in at 1:30, but you know me, I'll have her respectfully wait a little bit, and then I'll send you all on your merry way. But let me just talk about some of these subjects that we're going to see on multiple choice. So procedure, right? The procedure, dates and times thing is important. You got to know what are the differences between federal and Florida. So I could literally jump into Hannah's colorful outlines, because we need to see some colorful stuff, and just see like what are the important dates and times to these things. Okay, so complaint is 120 days, right? That's an interesting one. The interpleader versus the impleader versus the intervention. Intervention is third party jumping in. Impleader is pulling someone in, and interpleader is, forcing two defendants to dispute amongst themselves. Remember, compulsory counterclaims, right? As it says here, same transaction or occurrence. Things like that, like lease pendens. If the underlying case is dismissed, the lease pendant will automatically be canceled. 20 days is usually the timing that you have to respond to things in Florida, when it comes to it, right? 120 days for the complaint, 20 days, to respond to most things, 10 days to respond to an amended complaint, right? 15 days after the verdict for a belated directed verdict, and 15 for a new trial. So those are different from the 28 days in federal.
Hey,
And
Andrew,
yeah, what's up?
a quick question with respect to the belated directed verdict. What's the difference between a belated directed verdict and a like renewed directed verdict, or are they like the same or different things?
So it's just different terminology that they use in federal and Florida courts. In federal courts, they're going to use JMOL, judgment as a matter of law, or renewed JMOL. In Florida courts, they use a directed verdict or belated directed verdict, and sometimes they use JNOV, judgment notwithstanding the verdict, and renewed JNOV, which I think is a little bit archaic, but I'm not sure that FBBE is. No, I'm just kidding. But they're supposed to use directed verdict and belated directed verdict in Florida, and then in federal they're going to use JMOL and renewed JMOL, but they're essentially the same things. The only difference are the timings, right? And what they're called, but the standard is the same, that no reasonable juror could find for the non-moving party. So, civil procedure, very tough subject. I mean, it's kind of like so much stuff you could learn here. And then criminal procedure, speedy trial days. So if there's no demand, you have 175 for the felony and 90 for the misdemeanor. If they make the demand, and they have 50 days. So the demand has to be made within 60 days of the arrest, and then they have 50 days from the date of the demand. And then there's the recapture period, right? Which is like the 5 days to hold the hearing, and then they don't show good cause, then double jeopardy will attach within 10. So there's technically a 15-day recapture period after the speedy trial demand is made, right? The expiration of speedy trial time. Jurors, 12 in the capitals, 6 others, peremptory challenge, 10 capitals, 6 in all other felonies, 3 misdemeanors. The adversarial probable cause hearing versus non-adversarial. This is when they're not in custody for a felony. They have 21 days to bring it. And this is when they are in custody, and they have 48 hours plus 2 24-hour extensions to determine probable cause. Right, the release thing, this is the 30-33-40 rule. If the defendant is in custody, the state has 30 days to charge. If not on the 30th day, the defendant must be released on the 33rd day, but they can show good cause and extend it to 40 days. So these types of dates and times, aren't important until they are, right? You can see I found Hannah off Reddit, and I hit her up. I was like, yo, I need these charts. And she's like, I need to come to your class. And we became friends ever since. I still am friends with her. She's a really active golf player. She got super into golf, and she got married, practices law. get what you wish for, right? If that's what you want is to practice law, all you gotta do is pass this test, and then you'll be working in the field that is probably has the highest depression rate of any profession. But you can't complain. People who prayed for what they get cannot complain to me. That's something I always say. If you prayed to me and said, Andrew, I really want to pass this bar and become an attorney, I never want to hear you complain about being an attorney. And trust me, all of them do, because that's how people are, man. All right, so not saying that about Hannah, but I'm just saying that about a lot of students. Hannah's actually, she's never complained. Hannah's dope. I really like Hannah. Okay, so there's some crim law stuff. I mean, you know, it's tested in a manner that's difficult, but I think the best way to understand it is to just do the practice questions and key in on the dates and times. And you know, when Amy says that she has like time to do shit charts, it's like crim pro time to do shit. I mean, this is a amazing chart that, yeah, like I could go over these things, but more important that you just access this, commit it to memory, and you'll do just fine. It's kind of the same thing with evidence, right? Like evidence is really, really difficult. I think these materials are really great, like, and these PowerPoints, some important things like Florida does not allow opinion, only reputation for character evidence. Florida does not have the learned treatise doctrine. Florida does not allow for the testimonial spousal privilege, just the Meryl communications one. The dying declaration applies in all cases in Florida, not just homicide and civil cases. So there's definitely a lot of differences between Florida and federal when it
Hey,
comes to.
Andrew, I had two questions regarding evidence that I got confused with when I was doing the Barbary questions. So regarding the testimonial one, does that mean that the state can compel for non-communications a spouse to testify against their other?
Yeah, in
Okay.
Florida, not in federal. That's what that
Yeah, in
means.
Florida. And then
Unless it's well, I won't even get there. Okay, what's the next question?
next question is when, I mean, obviously there's a lot of scenarios, but like
Let's keep it
when,
simple.
yes, like when the thing that they're impeaching with can be used substantively, because there's many instances where
The
it
best
can't.
example is if
There's
it's
again.
made under oath, right? If it's an inconsistent statement, a prior inconsistent statement made under oath, then not only is it going to be able to come in for impeachment purposes, but could also come in substantively because, yeah, it's already been subject to cross. It was under oath. So that's the best example is if the prior non-consistent statement was made under oath, then it should be able to come in substantively as well. To be fair, I don't teach Barbary questions. I didn't write Barbary questions. I have no idea what those questions are about. So you just have to look at their explanations. But you know, these questions probably have more understandable explanations. But anywho, when it comes to evidence, you know, Florida can be very tough. I think that's the hardest part of the test to score well on because you have to remember the distinctions between Florida and federal evidence. So if it were me the night before the exam, I would be actually up on Amy's materials, right? The study materials that say timing, civ crim pro time to do shit, you know, the one that's the difference between Florida and federal evidence distinctions. I mean, that's a really good place to start. So here, where it comes to evidence, we have two charts that show distinctions, right? This one has all the differences between Florida and federal horizontally, and this one has all the differences kind of in this pretty little chart, right? So definitely recommend you go over these and know them well. Like the judge in Florida could potentially speak on a purely formal matter, but otherwise cannot, right? In federal, they can't talk at all. These are the privileges. Florida also recognizes like the journalist, sexual counselor victim, human trafficking advocate victim, the accountant, and the trade secrets are like additional recognized ones. In Florida, right, they don't recognize learned treatise. It can't be used as substantive evidence. However, it can be used to impeach an expert, right? Little things. I mean, I'm telling you, Florida evidence is really, really tough, but I really like this distinction chart. I think that could be a good thing to look at down the stretch. When it comes to, you know, wills, I mean, Marion got a perfect score on wills. You see what I've assembled here? Like, this is the gooniest goon squad of all time. I got the, you know, Avengers. I got people who have scored perfect scores on this exam, creating PowerPoints so that we can learn from them. So, like, highly recommend you go over Marion's wills PowerPoint. I think the key concept, like per stirpes, we're going to split things up on this first stirpial level. A, B, and C will each get 33%. If C is dead, 33%, 33%, and then C's kids will split that 33%, right? Yeah, really, really good PowerPoint that goes through Persterpes, the half-bloods things. So let's see, half-blood siblings. Florida law treats half-blood sibling relatives differently than treats whole-blood relatives. Half-blood relatives are areas related to the decedent through one common parent or grandparents. I mean, we get a fucking half-blood is. Half-blood relationships occur, not the same Marians, I'm just trying to get through this. Half-blood relationships occur only with collateral heirs, not with decedents or ancestors. Under Florida statute, each half-blood heir receives only half as much as the whole-blood heir. If only half-blood families survive, shares are equal. So this is exactly how I would calculate it. I think me and Marion are unique on this. Most people don't know how to do this. Most people try to do it as like a full blood counts as one and a half blood counts as a half, but then you end up doing fractions. We don't like fractions. So it's easier to do a whole blood as 2 and a half blood as 1, and then you add them up, and that's how you'll split it up. So hopefully that makes sense to y'all. Testate estate, right? Strict compliance with the execution of wills. So it must be in writing, must be signed by a testator. It must appear the signature at the end of the will, right after the dispositive administrative provisions, and the witnesses must sign in the presence of the testator and of each other, right? You go into this whole line of vision test and things throughout that. I'm not going to go into that at all. Testimony capacity, intent, right? Sound mind. They got to be 18 years old. If you're going to revoke a will, it revokes the codicil. If you revoke the codicil, then the will stands. But the codicil cannot stand without the will. It has to have intent and physical act. So if you intend to revoke the codicil, but you revoke the will, you rip up the will, you've done nothing, because the two elements need to be contemporaneous. So strict compliance with revocation, revival. So just because you revoke a second will doesn't automatically revive the first will. You can only, say that a will was lost and attest to it if there's 2 disinterested witnesses who will testify, or by the testimony of 1 disinterested witness and a correct copy of it. So types of devises: specific, demonstrative, general, residuary. They kind of identify themselves. Abatement, ademption, accessions. Abatement means that the thing has abated, it no longer exists. I'm sorry, wrong. Ademption means the thing has been deemed, it no longer exists. Abatement means the thing has been diminished, it's been abated, and there's not as much value. Accession means that the tire has become part of the truck, and we can't really take the tire off the truck, but you could still see the tire. It's not commingled, but it is an accession. Damn, Marion killed this PowerPoint. Pretermitted, spouse and children, right? Like you can't just, if I'm the youngest in my family, my brother. So let's say my parents did their will after they had my brother Brian. Russell and Brian are born. Andrew's not born yet. They write a will, splitting the property between Russell and Brian, and then Andrew's born. Well, wouldn't it be kind of unfair if I didn't get anything? I'm sure, I think it's like the hope. I mean, after 35 years has passed, I'm not sure it's still the case, but at least at the time of my birth, I would hope that they would want me to have an equal share as my brothers. Right now, my brother Brian's got 2 kids, so like he's definitely the favorite. And then Russell is an American hero. He's a firefighter in Alaska, so he's probably second favorite. So that leaves me, the black sheep. Wills, anti-lapse statute, right? We have an anti-lapse statute. So if it's gonna go to a person, but that person has died, then it's gonna have lapsed, except Florida's anti-lapse statute will save it for pretty much one of their heirs or next of kin, let's say. Some more topics to review. Yeah, you should review these on your own. Marion, you can hit her up, tell her I sent you. We love Marion. She, I think, got the highest score of anyone on my staff, including a perfect score on wills. So, I believe in the concept of A players only, and Marion's definitely an A player. Speaking of A players, Rebecca, also another A player. She's incredible, barred in New York and Florida, and practice trust in the states. These 2 PowerPoints, if you're not sure about wills or trust, go over these 2 PowerPoints and they'll give you everything you need, right? Creation of a trust, capacity raised, trustee, ascertainable beneficiaries, intent and valid purpose, right? Legal title, la-di-da. Cypress doctrine, right? If it's supposed to go to a charity, that charity no longer exists, then we'll just give it to another charity that's kind of similar. Spendthrift clause, right? I call this the Chet Hanks provision. That's Tom Hanks' idiot son. No offense, that's not defamation. He's truly an idiot. I mean, I don't know, but he has an album called White Boy Summer or something. So like, it's pretty dumb if you ask me. But anyway, Chet Hanks, yeah, this kid, his tattoo parlor comes after him with a huge bill because now, like, I think Pete Davidson spent $200,000 getting all his tattoos removed. Also the type of kid who probably need a spendthrift provision, right? Like if you're gonna spend $200,000, Chet, to get your tattoos removed, well, shit, the tattoo parlor can't come after the corpus of the trust because there's a spendthrift provision, which means you can only access the, disbursements, not the actual corpus. So that's a spendthrift provision. Who can pierce it? Alimony, child support, Uncle Sam, government taxes, and claims from attorney protected the beneficiary's interest in the trust. Kind of similar to a homestead exemption if you think about it. Fiduciary duties. Just because the value of the trust goes down doesn't mean the trustee has breached any duties. He's, protected by the business judgment rule. Duty to inform, duty to account, duty to, income to the principal type shit. Modifying, terminating a trust. The hallmark of trust revocation and modification is settler intent. You're probably going to have to petition to the court to get it modified or revoked if the settler is passed. Semi-secret versus secret. These are mentioned in wills. Secret names beneficiaries and they'll impose a constructive trust. Semi-secret means that the trust will fail because they don't name any ascertainable beneficiaries. Questions, please ask. You can hit up Rebecca. This is her law firm. Oh shit, I didn't mean to do that. But she's amazing. Rebecca and Marion, they're the type of people who make me very confident that I'm gonna be able to not necessarily retire, retire when it's time, but at least move on to the next thing because I can trust that they can teach, they can do PowerPoints, they are the future and the future is bright. So business entities, Barbara's got super dope outlines. I love business entities because I own a business, I have an MBA, but you don't learn anything in business school about business. You don't learn anything about the law in law school. You got to learn these things in practice. And business entities is a tough subject. There's some important things that definitely are, important to note, and especially understand the differences between the organizations. Like sole proprietorship is a one-man band. Partnership, so general partners are personally liable, right? And then if it's a limited partnership, it'll have a general partner and a limited partner. General partners are personally liable and manage the business, whereas limited partners, their liability is limited to the, just their investment. C corps and S corps. C corps are double taxation and limited liability. S corps are going to be, elect to have flow through taxation and limited liability. Same thing with LLCs. LLCs will have flow through taxation and elect limited liability. So S corps and LLCs kind of attach, arrive at the same destination, which is limited liability and flow through taxation. This is from, you can see this is from the National Association of Tax Professionals. This is a lot more than you need to know. But if you're struggling with, LLCs, S corps, C corps, partnerships, sole proprietorships, that's a really good outline. I think when it comes to business entities, I do a pretty kick-ass PowerPoint that y'all should definitely go through. See, Rebecca and Marion don't put like pictures. Like I put pictures of myself, I put pictures of my favorite places. They're much more professional to the point. I'm much more like whatever I am. So yeah, stocks and bonds, common shareholders have voting rights. Preferred shareholders have dividend priority. Those are some kind of main things you should understand. Perfection, de jure is proper. De facto is, is kind of messed up. By estoppel means that third party didn't, know and they were representing themselves out as a corporation. We talked about LLCs, S corps, things like that. Piercing the corporate veil, alter ego doctrine, thin capitalization, deep rock doctrine, subsidiary corps, right? We're showing that there was an improper purpose. There was, thin capitalization, or there was an alter ego, and this is how you can go directly after the shareholders or after a parent company. Stocks, they have these voting rights. Preferred stock have dividend priority. Debt securities like bonds and things like that. This is liquidation priority if the company goes broke. Wages, taxes, creditors, secured, unsecured, junior unsecured, preferred stockholders, and common stockholders. Promoters, right? Promoter liability. So even after the corporation is formed and adopts the pre-incorporation contract, the promoter remains personally liable unless there's a novation, right? Derivative suits. So a direct suit is suing the company. A derivative suit is suing on behalf of the company, but you have to at least give them notice that you're going to do a derivative suit and demand, right? Unless demand is futile. Mergers and consolidation. So mergers will actually trigger a vote, right, from the from the common stockholders, because it's a fundamental change. Rules and regulations, look out for, 12b5, insider trading. Martha Stewart's going down. She knew what she was doing. Blue sky laws. When I took the Florida bar exam, they tested business entities. I remember they're asking questions about blue sky laws. Just pick the answer that talks about intrastate securities. Blue sky laws talks about intrastate, within the one state. Blue sky laws are state securities. Yeah, business entities can be really, really tough. They ask a lot about partnerships and corporations. We have some really good, outlines and materials when it comes to partnerships and corporations. And I think if you look at like the business entities questionnaire that we do, it pretty much puts you on point with all the things you need to know: dissolution, piercing the corporate veil, agency. They talk a lot about like, A and B are partners, A buys toilets, is B bound? The answer is usually yes, right? Unless it's so far out of the scope of the business and there's no way to bind them, usually B will be responsible for the toilets bought by A because they are, partners together. All right, so those are the main topics. Then we arrive at the very final ones, which are commercial paper and secure transactions. These are concepts I could teach in my sleep, right? They're very, very simple. You just got to know a few points when it comes to secure transactions. I think the main points are like the security agreement. That's how you attach. You attach by security agreement. You perfect by financing statement. So attach by security agreement, perfect by financing statement, unless it's something you could have by possession or control, like accounts receivable or chattel paper or something. But usually attach by security agreement, perfect by financing statement. Different types of collateral: tangibles or consumer goods, inventory, farm products, and equipment. Intangibles are, things you can't really touch. Attached by security agreement. PMSI is a purchase money security agreement. It's just like a purchase money mortgage. The PMSI will have super priority if the money is lent and used to purchase the collateral itself. Automatic perfection in PMSIs and consumer goods, 20-day grace period for PMSI and non-consumer goods. Perfection is how you put other people on notice, right? And you perfect by financing statement. If it's on an actual car, you need to note that on the certificate of title. Priority, it's first in time, first in right. Unperfected versus unperfected, first to attach. Perfected versus unperfected, perfected always wins. Perfected versus perfected, it's first in time, first in right. Only if it's a PMSI will they have second in time, first in right. Default, the defaulting party, if the debtor defaults, then the secured party has the right to possess. To repossess, you'll need to seek a writ of replevin if they cannot do without breaching the peace. Any questions? Holla, Andrew@ibisprep.com. Follow me. This is a real quote by Helen Keller. I can't believe it, but it's a real quote by Helen Keller. This just shows how lit she was. She had the fortitude to tell people this: never bend your head, always hold it high, and look the world straight in the eye. Someone who is blind is telling y'all to look the world straight in the eye. That's a phenomenal quote. I didn't even believe it was Helen Keller when my one of my assistants made this slide for me in 2021. And then I Googled it. I was like, wow, that's pretty deep, Helen. All right. And then last but not least, my favorite subject, commercial paper, right? Commercial paper: a signed, written, unconditional promise to pay a fixed sum of money with or without interest on demand or definitive time to order or bearer with no additional undertakings. What? A signed, written, unconditional promise to pay a fixed sum of money with or without interest on demand or definitive time to order or bearer with no additional undertakings. Commercial paper is muy fácil, right? Don't make fun of my accent. What is it? Negotiable instruments. It's, a medium of exchange that stands for money that does not apply to, cash or securities. Notes are two-party instruments. Drafts are three-party instruments. The maker is the one who makes it. The payee who can get paid. Drawer is the one who draws it. The drawee / payor in a draft will be the bank, and then the payee is the one who gets paid. Remember this: signed, written, unconditional promise to pay fixed sum of money with or without interest on demand or definitive time to order or bearer with no additional undertakings. This slide right here, if you just remember this, you'll get most of the questions right. Tommy gives a note. It says, I, Tommy, do promise to pay Johnny the sum of $50,000 if the Chiefs win the Super Bowl. Well, too bad. Chiefs didn't win. You're not going to get paid. But too bad. It was never a negotiable instrument in the first place because of that condition of negotiability, right? So, that's a common answer. This is not going to be regulated by Article 3 because there was a condition, because it wasn't signed, because it wasn't written, because it wasn't a fixed amount, because it wasn't payable on demand or definitive time. These are all reasons why it wouldn't be negotiable. Forms of negotiation: bearer paper, you negotiate by possession, order paper, by transfer and endorsement, right? Signature. Holder in due course. This is just like a buyer in the ordinary course of business for secured transactions. This is just like a bona fide purchaser in real property. This is someone who takes for value without notice in good faith. And if they do, they will be only subject to the real defenses and not the personal defenses. The real defenses are fraud and factum, alteration, illegality, incapacity, and duress. While I have this up here, this is this dude, Sailor Moon, no, Sailor GitHub. He does a really good job of talking about commercial paper secured transactions. I learned a lot from him. And by the same token, there's also someone named Hornsby, I don't know what his first name is, but this dude Hornsby, right? Look at this guy. Top, me and him, IBIS Prep has won this for the past couple of years too. Best rated business by 3 best rated. We should stick it on our website and stick a picture of me looking all handsome. But anywho, this dude does an amazing job with the crimes. So it's hornsby.com/crimes, and then this Sailor GitHub. I'll put both of these these links in the chat when I have the chance, but really good stuff right here. This Sailor GitHub, and then this Hornsby law firm thing, right? Okay. So transfer warranties and presentment warranties. Transfer warranties, it's not fraudulent. I give the check to Tommy can transfer it to Johnny. And then presentment warranties, if I present it to the bank is going to pay me out, and there's nothing, altered or wrong with it. Pretty simple. I mean, there's some other things about commercial paper, secure transactions, trust, wills, business, and like family law. I didn't get too deep into Civ Pro and Crim Pro today. Reason why is because, you just need to know the formalities of Florida. Otherwise, it's going to be the same types of questions you would see at federal law. But don't think that by any means procedure is not important. If I were going to do my question bank, I would do more procedure questions than anything else, because, that's guaranteed to be tested. And then I would do these, FBB practice questions, and then all these ones at the bottom, including my most recent final exam, which I think is pretty solid and complete. So right here, I'll put this dude's stuff in the chat. This is the guy with the crimes, and I think, you can go over to Florida crimes. And then this is the guy who does commercial paper and secure transactions. I really like these websites. But yeah, I know I probably lost a lot of people, but surprisingly, still 16 people left in the room. As you do know, I have a student in here because we were supposed to start a little bit ago, and Gabby will start as soon as I take a quick break. I also have class. I have class at 4
about to say
o'clock.
you gained one person.
Yeah, I have class at 4 o'clock too for the UBE, so I'm gonna have to teach a 3-hour class then. So there will be no break for me. But I really appreciate everyone for hanging out with me. I wanted to end this on a strong note. My whole belief about everything is, finish strong. You didn't do all this work for you to fizzle out at the end. All that matters is how you perform on test day, not how hard you worked. Unfortunately, the hard work will pay off though. So I want everyone to go out and put their best foot forward. I'm about to put this video on YouTube so you can watch it again if you feel the need. But I would really focus on the 2 materials that I highlighted: my essay guidebook and the Florida multiple choice question bank. Gabby, who's in the room, has already passed the Florida bar. So she's, working on the MBE, which we expect to pass this time. And then I teach for the UB in California, and I'm about to become the king of the next gen bar. So hopefully this won't be the last I've seen of all of you. I will be in Tampa. Hopefully you say hi to me. I'll be at American Social on Wednesday night, 6:45. We got the reservations. But between now and then, it's business, right? If you come to this test to pass this exam, and then we'll hang out afterwards. So again, I really, really appreciate everyone for hanging with me. I'm gonna go ahead and stop this recording.